May I have your lordship's kind leave to not pray for and not filing for special leave to appeal without certified copy. Not we have got the net copy of the order. The special leave to appeal we have the read.
When did you apply?
Not the initially not I applied on 5th of September, but my that certificate copy was not filed for another appeal. That's a clerk mistake. But the order was passed on 15th December, but termination order was given effect in 29th of August. Thereafter, not I applied for one certificate copy. That certificate copy was used for not filing appeal. But I was not party in the writ petition. My service was terminated. Thereafter, I again applied for 27th. That's just day before yesterday.
Get the certified copy and
I'll
procedure of obtaining certified copy is becoming obsolete now. Everybody comes and prays for leave.
Under
the civil rules and order, there are specific provisions.
But we have applied, but now it is
applied, you slept till from December till date.
No, December, that was not given effect to. The order was given effect to on the 29th of August.
We are in September, order was of?
Order of 5th of December 2022, but order was, I did not have the knowledge of the order. My service was terminated.
What is this? This is a leave to appeal?
He is leave to appeal, my lord. That's why, my lord. I was not made a party in the writ petition.
May I be permitted to mention, I am mentioning for inclusion under the heading application. This is group 6 matter, my lord.
Group 6?
Yes.
Yes, give this slip.
Lordship, may I be permitted to mention a matter for non-prosecution? Lordship, may I be permitted?
Wait for the lordship. For inclusion of the application.
Application or?
For mandamus appeal, my lord. For inclusion.
Yes.
But I'm praying to be.
You আসেনি জয়ন্ত ভান্ত? Yes, call the list.
In this matter, Mr. Siddhartha Banerjee is appearing. Due to traffic jam, he couldn't reach in court. Kindly pass over the matter.
In fact, Lordship has heard Mr. Banerjee on last date, that matter.
Tuesday. It will be on Tuesday as to be mentioned.
Lordship.
Deeply obliged.
Obliged.
My lord, 225, Mr. Devabrata Chatterjee appearing. He is on the way, my lord. Kindly make it pass over, my lord. Short pass over.
I'm
for the petitioner, my lord.
Why extension of interim order it has?
My lord, it has wrongly recorded, my lord.
Wrongly
It is a habeas corpus matter, my lord. WPAH.
Yours is first time it is appearing. Your matter is appearing for.
my lord, item number 4, my.
Is appearing for the first time.
Item
My
number.
lord, my lord, the on
Which
last
item,
occasion,
my
your
lord?
lordship,
Item
my
number
lord,
2.
your lordship,
My lord, last occasion state has, my lord, appeared.
no, because my lord, my Lana sister, my lord, submit.
Number 2. Are you
Oh, no,
number 2?
no, my.
Where?
My lord, state has appeared last occasion, my lord, and prayed for time. So far, my lord, my knowledge is concerned.
Who is there? Your other side?
My lord, Mr. Devabrata Chatterjee.
In item 2 also.
Yes, 225, my lord.
Where is he?
My lord, he's on the way. Make it pass over. Short pass over.
Pass over. Yes.
The affidavit of
Three.
my lord. This is the case where my lord.
6.
225 pass over.
225.
I am the petitioner in 3, my lord.
I'm
Yes,
the
yes.
respondent, my lord.
The state is
State,
pass
appearing for
State.
state. Yes, state pass.
Well, only one thing, my lord. I am appearing for the private respondents 3 to 5, my lord. I have not received the wakalatnama. If it could be taken on Tuesday, my lord. Item number 3, my lord.
What do you say?
This is the, my lord, where my lord, my daughter has been taken away by my lord, the brother-in-law and
My
the
lord.
wife.
Oh,
After my wife died, my lord.
State.
If it could be taken up on Tuesday, my lord, this matter.
we are on item number 3. Who is in item number 3?
I am in 3 for the private respondents, my lord.
Yes, what is your prayer? What your
Well, I was humbly praying if this could be taken up on Tuesday, my lord. I have not received the Vakalatnama. It was
copy you have received?
copy. They're sending, they've couriered it, my lord. The writ petition I have received over mail. But my lord, there are instructions which I need because I just received it yesterday, my lord. So some accommodation on Tuesday if I can come back, my lord.
Not today. Yes.
Grateful.
One, 3 to 5. So what's your?
4 my lord, I beg to appear.
4, 5, the 4. Pass over. Pass over. তারা দিয়ে না, আমি তো ওটা তাদের তখন আমি
Yes, what is the matter?
My lord, on your, my daughter has been kidnapped, my lord, by, my lord, the private respondent, my lord. And thereafter, my lord, on last occasion, your lordship,
Have
my
you
lord,
served upon the private respondent?
my lord, I have, my lord, served, but not, my lord, checked, my lord, this track report, my lord, I have to check track report. Your
Where
lordship,
did she
4
go?
also, my lord, 3 to
Where did she go? She was just now here.
my lord.
Call her. মাদুরামোর লিমিট নেই। Yes, why did you leave the court? You are in this matter?
Lordship, I sincerely apologize, but I have been instructed that my learned senior will be doing the matter.
Why the records are not with you?
As records,
When sir she will arrive in court? Till when do we wait?
I sincerely apologize, Lordship, but since it was a direction from the learned senior, so
So
sincerely
your
apologize.
service is complete upon the private respondent?
my lord,
Instruction.
dispatch, my lord, but track report has not yet been, my lord, I have not been, my lord.
Yes, what is your instruction?
Lordship,
My
just
report filed to your lordship's direction.
এটা accident. তখন শ্যামল,
তখন শ্বাস-
শ্বাসমূল. Lordship, we have not received the instructions yet, Lordship, in this matter. জানি আর রিসিভ করে নিয়ে রিপোর্ট আসেনি।
Complete your service and come back on Tuesday. Tuesday you would be able to do it.
My lord, one thing, my lord, as per, my lord, petitioner's instruction, my lord, on Debra police station, my lord, it is informed that her, my lord, daughter has been recovered, my lord.
Daughter recovered.
My lord, that is from, my lord, this,
Are you are his counsel.
my lord.
What he has instructed you?
My lord,
Daughter
instructed, my
recovered.
lord, from the Debra police station, it is informed that his daughter is, my lord, recovered, my lord. But my lord, within this time, my lord, I have, my lord, made a, my lord, complaint that all the movement of the petitioners and his family under surveillance, and my lord, my lord, the several, my lord, threats from the, my lord, the private respondent, and which is, my lord, the supported by the, my lord, the Panchayat Pradhan Sheikh Tafizul Hossain on that ward, my lord, has been, my lord, initiated, my lord. That is, my lord, I have, my lord, he has, my lord, made a, my lord, the complaint by the, my lord, Pingla police station. My lord, nothing. My lord, my lord, he's completely, my lord, he's under fear, my lord. That is the main thing. He's all the movement, my lord. Last occasion, my lord, he, my lord, came to this court, my lord. When he came back, my lord, the home, my lord, the Panchayat Pradhan, this, my lord, oh, তোরা কোর্টে গেছিলিস, দেখ তোদের কি হয়। This language, my lord.
সেটা তো ডিফারেন্ট কিছু।
দাঁড়ান, দাঁড়ান।
অমৃতা তো আমি
You have no instruction.
Lordship, as on date, I do not have the brief even. I sincerely apologize, but I do not have the brief also.
Ask Mr. Chatterjee to be here. Ask him to appear. Pass over করে রাখ। এইটা ওনাকে দিয়ে দাও। Take back your copy. Take back your complete copy. And search out the track report in
My lord,
the
my lord.
meantime.
And for the state, Lordship.
সুদ দিতে হবে নরমাল সার্ভিসটা হয়ে গেল কে ওকে এনশিওর করতে বলবি প্রেজেন্স yes
Lordship, I'm for state, Lordship, but
who is for the petitioner পাসওয়ার্ড করে রাখো so you don't have
yes,
instruction
this I have got instruction.
let it be passed over no anybody for the petitioner nobody is for the
No,
petitioner.
Lordship.
Then not today
Okay.
yes
Wait.
immediately ask him to come
Yes, I sincerely apologize, Lordship.
আগের দিনও ছিল এটা আগের দিন ছিল নাকি দেখুন
But in this matter, I am for the petitioner, my lord. My lord, I am for the petitioner, my lord, and we have served notice upon all the respondents. My lord,
I'm for the response.
the fact of the case is this, my lord, that it is a way application is pending before the learned tribunal, my lord. Because the application has been filed setting aside the seniority list published by the respondent authorities, my lord. And the stay order was granted by the tribunal on 5/8
in your favor
2020, my lord. Thereafter, my lord, it
the
was
order was in their
granted by
favor.
the learned tribunal on 5/8/2021, my lord. And thereafter, my lord, and the order is given there. So by virtue of this order, the trade test which was conducted, that has been stayed, and the procedure is that for getting promotion from the in-service quota, all the candidates should appear in written test examination. There should be a training for 6 months, and
Where is your 5th August order? Which order you are assailing?
my lord, this is 5/8/2021, my lord.
Which page?
My lord, I filed the original copy of the order.
But they're not subject to correction, or they're not assailing any order.
No,
They're
my
praying
lord.
for expeditious
Only
disposal.
expeditious hearing of their order, my lord. Because, my lord, this matter is kept pending for a long time. I have made application before the learned tribunal for disposal of the order, for by vacating the interim order. 22 adjournments are given from the learned tribunal, my lord. Matter is kept pending. So this is the one of the adjournment. I have annexed those documents. Each and every time adjournments are given, an interim order has been continued. So my client as well as the are suffering, my lord.
But you were present during all the সাহেবের briefটা কোথায়?
Both but because there's single bench, it should be in the division bench, my lord.
নেব কি করে? কোথায়? পিয়ন কোথায়? Next date fixed.
My lord, next, as per my instruction, next date is fixed in next year. Maybe in the month of December or January, my lord, because 22 adjournments, because there is a shortage of bench.
When
My
is
lord.
the next date fixed? Do you know when is the next date?
The last date was 2nd of August, my lord.
2nd of August.
August was the last date.
Yes, my lord. Thereafter,
Who is praying for adjournment?
because my lord, the problem is, my lord, initially the order was passed by the Honorable Division Bench under Tribunal. Thereafter, the single bench, so single bench could not take the matter. Accordingly, both the parties, if you let me kindly peruse the documents I have annexed, page 56.
Pauni.
One of the London Tribunal is present, man. So, my lord, as because the quorum is not there, so matter got adjourned in presence of both the parties. In this way, it is.
Please come on Wednesday. The other file is not traceable. Patient.
I may just subject to correction of my lord. If your lordship adjourns, my lord, all right. Otherwise, my lord, there was not a single date when the respondent, my lord, prayed for adjournment. As per the orders that has been annexed by my
My
lord.
brother does not have.
My lord,
brief.
in both
Do you
the.
have any problem on Wednesday?
No problem. No
Yes,
problem.
Wednesday.
Wait a minute.
And you ascertain when is the next date fixed.
Yes, my lord.
And whether your vacating application is still pending or not.
Yes, ma'am, that is pending, my lord. That is pending.
Come back with the date on which it has been fixed.
Yes,
এই
my lord.
ফাইলটাকে বের
I know
করতে
both
বলো।
the parties are present, but because of the thing, my lord, the matter could not be taken up. I should come, my lord, with it. I'm obliged, man.
I'm sorry, ma'am.
Item number eight.
This matter made by Mr. Som Mojumdar, my lord.
এই একে ডাকো তো সুব্রত।
Mr. Som Mojumdar. My lord will find, my lord. I'm challenging the. Matter, my lord. My lord, while I'm challenging the order passed by the Central and Tribunal, my lord. My lord, the issue is very short, my lord.
Which is the order you are challenging?
My lord, for your lordship's convenience, my lord, I have already annexed, my lord. If my lord kindly comes to page.
You are appearing for all?
I'm appearing for the Steel Authority of India respondent.
My lord, page 532, my lord, second volume, my lord, once, my lord.
Union of India party. Union of India is also party to this proceeding, my lord. I'm not representing the Union of India.
Have you served upon
My lord, all sir, my lord.
their presence is required?
Their
Or
presence
this
is
application
not
is
required.
Against sale, my lord.
Not required.
Yes, what?
My lord, if my lord kind comes to page 532, my lord find para 5.1. My lord find learned counsel for the appellants fairly.
For the applicants,
My lord,
you were for the applicants.
my lord.
Yes,
Not the petition today survives for interest on belated belated remittance of arrears of pay revision. Not there was a pay,
tribunal has not granted.
no, not in fact, there are two grounds taken by the employer. The arrears of pay revision were to be granted from 1/1/1997. This was disbursed from 2016-17 onwards. Now, I'm not in one of the
Mr. Mujumdar, why so many persons are there? More than 1,000 persons are participating.
they all joined in one application before the tribunal. That's permissible.
That has been allowed.
Application for taking up other matters analogously, that was disallowed. The emails were disallowed.
Then they were added as they are similarly situated with you.
There were 1,200 and odd original applicants before the learned tribunal.
1,200 and odd in one application.
Yes, that's not in terms of the tribunal rules. Now, not in this writ petition, some of them are writ petitioners and some of them are pro forma respondents, since they could not join as petitioners, and I could not have disarrayed them from the array of parties. But not, they are all similarly, the pro forma respondents are all similarly situated like the writ petitioners. Now, not on the ground of delay, the employer's objection has been overruled by the learned tribunal. Because the tribunal said that when in 2016 the employer issued a notice to disburse the arrears of pay revision, it gave rise to a fresh cause of action to initiate appropriate action. Now, not on the question of misrepresentation of facts, not which is really taken on record on the behalf of an executive batch of officers who had not disclosed that certain amount has been received. All the original applications were dismissed.
Since certain amount has been received.
Yes, not during the pendency of the original, not it was started releasing from, it got started released from 2016-17, 17-18, 18-19. For these 3 financial years in 3 installments, SAIL had disbursed these arrears of pay revision following an order of the tribunal in another matter which was upheld by the Honorable Supreme Court. So till such time the matter got rested before the Honorable Supreme Court, SAIL did not disburse. After Supreme Court dismissed the SLP, they issued a general notice saying that we shall be paying the arrears of pay revision from 1997, but in 3 installments. Now, not the prayer as on the date of filing of
said before the Supreme Court.
This was upheld by the Honorable Supreme Court. No, after the Supreme Court, order.
After the Supreme Court order, they said we will disburse the arrears in 3
installments. In fact, the original application, which was allowed in another batch of matters, the tribunal granted 3 equal installments with 6% interest. So after this general notice was issued, there was a batch of original applications filed before the learned tribunal, some by the workmen, some by the executives. But the writ petition is at the behest of the ex-workmen, who are all superannuated employees of SAIL. Now, the prayer had twofold parts. One, arrears of.
We are hearing the ex-servicemen.
Ex-workmen.
Ex-work order. That in their application, what happened? What did the tribunal say?
No, the tribunal said the employer's objection with regard to all the applications were dismissed. The employers.
What was the subject matter of challenge, that since in terms of the notice also they were not disbursed?
No, please disburse us the arrears of pay revision along with interest.
So why did the tribunal reject it?
Not on the ground of principally on the ground of suppression of fact, since according to the learned tribunal, it ought to have been said by the executives in their original application that some part of the arrears of pay revision had been received on the date of filing the original application.
But that was not at the instance of the ex-workmen.
Not at there. Please have a look at paragraph 8 of the order under appeal.
Now the tribunal rejected.
Yes.
Now what you have come up in appeal writ petition before this.
Yes.
So if it is this, their stand that we will disburse in 3 installments.
We have received, in the meantime we have received.
So you have received. Then what is your further grievance?
Interest.
But that was after the Supreme Court upheld the tribunal's order in the parent order, was there any direction for
Three
interest?
installments with 6% interest.
I see. So they have now disbursed the 3 installments, but without interest, and you received that without prejudice. Yes.
But in fact, not I should be fair before your lordships. Not when the original applications were filed, some of the applicants had received 1 installment, some had received 2 installments, but the entirety of the arrears of pay revision was yet to be received.
It's only the interest was.
No, part of the arrears had not been disbursed on the date of filing of the application.
What is the status today?
Today, they have all received the arrears in 3 installments. The claim survives for interest.
And it was the dates. So why did you try to?
3 installment.
Paragraph 3 of the writ petition, your lordship will get 2016-17, 17-18, 18-19.
End of October, তারপর October 2 মাস হচ্ছে November, December, পরের December, তারপর হচ্ছে January, February. 2015 যা কথা ছিল December 2015, February 2016, 3 মাসে দেওয়া ছিল। Since 1 year, the rate of all the whole 1 year.
Mr. Mukhar, why you are not paying interest?
My lord,
That was your circular itself. 3 installments, 3 without interest.
without interest.
Yeah,
And my lord, the try.
Page 9 to that. That circular, Mr. Mojumdar, was not with interest.
It was issued on after the Supreme Court judgment.
That they have quoted now in 8.2,
Yes,
but that does not say about any interest.
does not say about interest.
So you represented that you give me the interest.
And treat us alike the original applicants in the other matter who succeeded up to the Honorable Supreme Court.
And they were given interest.
Yes, yes.
They were given interest. My lord, these applicants are fence sitters. That was the finding of the tribunal. When initially, my lord, in 2014, some of the applicants, my lord, approached the tribunal, my lord, for interest, my lord. They did not file any application for addition of party or any original application. They were all along fence sitters. Now, when the tribunal passed an order, my lord, the tribunal very categorically mentioned that this benefit of interest should be extended to those who approached us.
Which paragraph?
My lord, kindly consider page 454 of this writ petition, my lord. Page 454. This is the order dated 6th.
454.
Second volume, yes. 454.
Order 6 July.
6 July 2012 order. No, I'm sorry, 26 July 2012. Now,
This was the original application.
original applicants who filed application in time. Now, your lordship, kindly consider page 455, last sentence, my lord. Our directions are limited to the applicants in TA 14 of 2011 only.
But Mr. Mukherjee, if it is your policy decision that we will pay the interest, we will pay the installments, and when in respect of certain persons it has been granted, why you are withholding in case of this?
My lord,
On the ground of being fence sitter?
no, my lord, there are certain facts, my lord, I have to take instructions, but your lordship kindly consider 3 aspects, my lord. First is,
So have you taken where, show us that paragraph where as fence sitters their claim was discussed?
yes. My lord, your lordship kindly consider
2nd of August
in the
2023 order, This is an application filed jointly by the workmen and executives.
No, separate applications.
Which are those separate?
Not
One
one-
is 813, another is 718.
7183 is the workman.
1718.
1718, I'm sorry,
This is of the
workman,
and the officers was 1813.
1813.
So they have also not been given interest.
Interest.
There is no scope for any interim order. It is only a question of determination of whether interest is payable or not.
Having provided in the accounts and having utilized our money, whether the employer is liable to pay the interest. 318 crores was made, provision for this amount was made in the accounts. It's recorded in the tribunal's order.
But is it a fact that your claim was rejected being the fence sitters?
No, I'll show to your lordship the order. Please have a look at.
Rather, the 8.1 and 8.2 relates to the, it appears that it is
Executives.
officers.
I'm grateful to your lordships. Please have a look at paragraph 8, that the point of delay as raised by the employer was rejected. If delay objection on the ground of delay is rejected, then it ought not to have failed even on the ground of being fence sitters. Because that's a fence sitter is a direct consequence of being delayed.
But where is the paragraph of rejection of your claim?
Kindly takes note paragraph 8.3.
No,
8.1
8 onwards, my lord. Paragraph 8.
Paragraph 8 onwards is the reasoning.
8.3 is pertaining to the retired executive.
Now please see the paragraph 8.4. We accordingly dismiss these OAs on the grounds mentioned in paragraphs 8.1 and 8.2 above. What is 8.1? 8.1 is records of sum are not being found.
8.1 is
Page 536 or internal page 8 of the order. It is apparent from the reply filed by the respondents that the service records of as many as 49 applicants are not available with the respondents. The applicants have not produced basic facts like their date of joining service or the date of their retirement. As per the reply of the respondents, one of the applicants left service in 1994. There has been no counter by the applicants to these charges. In fact, during argument, learned counsel for the applicants fairly submitted that directions can be passed upon the respondents to admit the claim of rest of the applicants, leaving aside the claims of such applicants whose service records are not available, implying that such applicants were indeed unable to prove their claims. OA number 1813 and OA number 1718, 1718 is this present application, have been filed joint.
One is 1813, you said.
Mine is 1718.
1813.
Today before your lordships is 1718.
By the what?
1813 is by the ex-executives. Have been filed jointly by 511 applicants and 1241 applicants respectively. All these applicants claim to be similarly placed as far as the relief sought for in this OA is concerned. However, confusion about even basic facts like absence of date of joining or date of retirement of a fairly large number of applicants points to an unacceptable lack of seriousness on the part of the claimants. Similarly, we also take note of the fact that a majority of the applicants had already received a part of the arrears when they filed these OAs in December 2017 and November 2018 respectively. This was deliberately suppressed in the OA as is apparent from the following averment in para 4 of 1813.
8.2 onwards relates to the executives.
Yes.
And so far as
8.4 rejects my claim on the basis of the averment in the original application filed by the executives, number 1. Number 2, if your lordship will kindly take paragraph 5.1, the learned tribunal was brought to notice that during the pendency of the proceedings, arrears had been received substantially. Internal page 4 of the order at page 532. 5.1, the last 2 lines on that page. Learned counsel for the applicants fairly submits that the arrears have been received by the applicants and their only demand now is payment of interest and with delayed payment.
Paragraph?
Not paragraph 5.1 at internal page 4 or running page 532, whichever your lordships are considering. Learned counsel for the applicants fairly submits that the arrears have been received by the applicants and their only demand now is payment of interest on delayed payment as has been paid to the applicants of OA 324. But that's the matter which went up to the Honorable Supreme Court. Following the directions of the tribunal, learned counsel submits that the tribunal's order has been passed in rem and all the payments including interest should be paid to all similarly situated persons. That was the scope of our submission.
But there is no observation as being fence sitters and everything.
No. But once the tribunal has held that there was no delay on the part of the original applicants, the tribunal could not have rejected our case on the ground of being fence sitters. Because that observation would run contrary to the finding then.
There is no such observation, my lord. We have taken this point. We have taken 6 points, my lord. Your lordship will find at paragraph 6. Out of 6, my lord.
Let us bury the hatchet. Now the funds have been made available. Now, if you have given to a bunch of officers or workmen along with interest, why you will deny this? Only on the ground that they have approached the tribunal later. But it is a policy decision on your
No,
part.
it is not the policy decision of the company, my lord.
That is after the SLP was dismissed.
Yes, and thereafter, my lord, when some of the officers, my lord, approached, my lord, the judgment passed by the tribunal, my lord, is categorically held that this is a judgment, my lord, in personam and not in rem. It was only restricted to those officers. Now, these officers were fence sitter, although, my lord, this point has not been, my lord, decided, but there are issue of territorial jurisdiction and other issues.
In your original application,
No, you are now going to give effect to the order passed in way number 224.
Yes.
Eh? Now, while going to give effect, you are saying that you have come in time. I am giving.
No, it is
benefit of that
the
order to
observation
you,
of the tribunal.
and you are late. So I will not give.
No, when the tribunal, my lord, disposed of the original application, the tribunal observed that the
Way 324 is TA 14.
Yes.
Yes, that was TA 14.
It was only restricted to the applicants. That has not been challenged. That has attained its finality. Now, today, my lord, can my learned senior friend, my lord, reopen this issue?
that went up to the Supreme Court, no?
Yes.
That went up to the Supreme Court, and after dismissal of SLP, you took the decision.
Yes, but till date, my lord, this judgment of this tribunal that has attained its finality, which says that benefit of limited to the person.
But the final judgment, your lordship will.
Have you brought on record the appeal court order and SLP
Yes,
order
yes.
in that?
Yes, yes. Please have a look at page 462. That's the final disposal of the original application in that.
In page 454, where is it that they were agreed to give it along with interest?
454.
That is the earlier TA which went up to the Supreme Court.
That's page 462. Please come to 462. That's the final order.
But in 4-455, Mr. Mojumdar, limited.
It begins at 456. 23rd September 2015.
This is another application.
So that's 324.
But 454
No,
is
no.
TA
14 is another.
TA 14.
14 to of 2001.
Yes.
Whereas 324 of 2014.
Yes. 324 went up to the Supreme Court.
So why we are saying that it has been limited only to
No,
the
I'll show to your lordship the tribunal's order, the division bench order, and Honorable Supreme Court's order. Please have a look at 456.
No, that is in connection with 324.
That is in connection with 324.
Now,
Yes.
what is the TA 2001?
TA 2001 was not similar application seeking the areas of revised pay scale. Not this was disposed of in terms of a commitment made by the ministry. Please have a look at page 455, internal page 4.
But we are not concerned with that.
No, we are concerned with 324 at 456.
T14 2001, Learned Counsel for the respondent.
Yes.
It was filed by retired person who retired from service in between 97 to
They were also the
2006.
they were also the original applicants in 324.
Yes. Oh,
Then why did they come to tribunal again?
But firstly, they came because the amount was not being disbursed. The court said, the tribunal said, since the ministry has given a promise, therefore nothing remains. We are not adjudicating, disposed of. Even thereafter, the company had not been disbursing, so they had to come for the second time, this time in 2014. Lordship may straightway come to page 462, internal page 7. That's the finding of the tribunal. Paragraph 10, if I may.
Only making interest in the list of annual every since individual applicant.
সুপ্রিম কোর্টে আরম্ভ করে interest
This was at the instant of the workman.
This was
Jitendra Kishore Gupta Rai.
No, I believe not, they are workmen. They were executives. Jitendra Kishore, they were executives.
Where is your original application?
And my original application begins at page 214. Not, it's a huge cost title. The readings begin from 395. Second volume.
Your claim was not adjudicated upon by the.
That's right. On the ground of an alleged misstatement made by the executives, not the original application filed by the ex-workman was also rejected.
This was on affidavits before.
After, yes, after exchange of affidavits.
Then we fix up and you submit our.
It's a very small part.
Very, well, your lordship, kindly allow me to file a short affidavit, my lord. I do not know. My lord, today my lord, this brief was given to
Affidavit to what?
to the this writ
The
petition.
application.
To this writ petition.
What more will you add?
So I do not know, my lord, whether all documents are in this writ petition or not. If anything, my lord, is not given, I shall produce.
You can file an affidavit of disclosure of documents, something like that. But, nothing is there in the stay application. It's all.
Although it's a pure question of law, but your lordship kindly give me a short direction for affidavit, my lord. I shall file it.
Now, so far as refusal of claim of executives, have they come before this?
So they are in the process of collecting the Wakalatnama, madam. They will also be filing. That's what I have been told.
সব document আছে তুই দেখেছো আমাদের রিটেন নোটিশ অফ আর্গুমেন্ট হয়েছিল
But the general notice said we shall pay in 3 installments, which say that if you have paid it for others, why don't you pay it for me?
This referral is from 2001 onwards. Ministry has disbursed 34 crores an odd. By which now if the interest fund has to be there in their account,
Yes.
how they will play?
It's provided 318 crores was provided for in the balance sheet.
Not with interest, Mr. Mujumdar.
Not one, not your lordships will not, interest is either by the act or by contract, or by equity. These are the three principles of granting interest.
The order with interest, you were not parties to it. Now that was of 2015 original application.
Yes.
Now you
2016, the employer said, I shall pay in 3 installments. That was to all. That was not limited to the original applicants in the successful original application.
That clear. You come to page 457.
Yes.
After setting out the paragraph 3 and 4, then according to learned counsel for the applicants, got it?
Yes, ma'am.
Earlier cited order itself is sufficient for being executed in favor of the applicant. Even for the purpose of getting extended the earlier order, the fresh way has been filed. The earlier way was filed by 132, most probably the retired employee. Now to get the benefit given in that order extended in respect of this original applicant, this applicant file OA number such and such. And by this time you only took point that we have no sufficient fund. No point that this benefit cannot be given.
No, my lord, here also, my lord, subject to correction, my lord, kindly consider page, the penultimate paragraph, internal page 7, 462. That was also, my lord, the tribunal restricted the relief to those, my lord, who approach the tribunal. Kindly consider in this order also. Page 462, the last paragraph, paragraph 12. In view of the, I'm sorry, ma'am.
Delay in making payment, yes.
Yes. Delay in making payment, simple interest at the rate of 6% per annum is payable ever since 1 year after the date of retirement of the individual applicant concerned, till all the payments are made to them. It was only restricted to those, my lord, those applicants, my lord, who approach the tribunal. Earlier also, my lord, I have shown that was also restricted to those who approach. Now, these admittedly, my lord, although this issue has not been decided by the tribunal, they were fence-sitters. They received amount which was not disclosed before the tribunal.
Not the finding of the tribunal.
No.
Tribunal
Only 1 point, my lord, dismissed the original application. Suppress some facts.
We are not going to
Yes, yes. Only on that point it was rejected.
On that point, but
yes,
their claim was not rejected, though it was hard to get. Instead of sending it back on remand.
No, my lord, your lordship, kindly decide this. Kindly decide. Kindly decide.
The present jurisdiction has been referred. Challenging an order challenge to judgment dated 2nd of August 2023.
Replay আছে, rejoinder টা ওখানে ফাইলও হয়নি তো।
Past
আছে বলছে। আছে।
Heard Mr. Mujumdar, learned advocate appearing for the petitioners. Mr. Mukherjee, learned advocate appearing for the
Steel Authority of India. Yes.
For respondent numbers.
My lord, respondent number
3 and 4.
Appearing for Steel Authority of India.
Yes, my lord. My lord, respondent number 2, 3, 4, and 5.
Opore evidence of service filed by the petitioners we kept. Heard Mr. Mujumdar, learned advocate appearing for the petitioners. Mr. Mukherjee, learned advocate appearing for the respondent numbers
2 to 5.
2 to 5. Praise for liberty to file an affidavit in opposition to the stay application. Affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within 2 weeks. Stop. Reply thereto if any be filed within 1 week after the vacation. Release the matter for final. The paper books are not required.
Not necessary.
Records are here. We will release the matter for further hearing. Daily supplementary service court on 12th December.
Grateful.
Grateful to your lordship.
So what to take? Both party.
For the petition.
My lord, I am praying sincere apology, my lord. I came before your lordship by walking from Dharmatala.
Huge traffic. Yes. Heavy.
Yes. Yes, this is your matter.
Well, item number 2.
Yes, tell us what is
The
your
petitioners are the my lord father and mother, or whose son gone missing from my lord since 2017, my lord. The private respondent, along with the private respondent, my lord, due to my lord the job purpose, he went to Bangalore, and since then 2017 he was missing, my lord. But page 3 is our complaint, my lord. 156 my lord. Of 3, my lord, the petitioner have been approached, and my lord, on Pursura case, being number 156 of 2017 has been registered, my lord. Since till then, my lord, the boy has not been recorded, my lord.
My lord, complete.
Why you are coming after 5 years?
It is pending, my lord. Aged parents, aged parents, my lord. Kindly
What is your issue?
My lord, in this matter, 2 case was filed by the petitioner. One before the Bangalore and one before the Pursura police station, my lord. And by the order of the learned ACJM Arambagh, the case has been transferred to Bengaluru before the CJM Bengaluru Rural, my lord. Kindly see the order of the learned ACJM.
Transferred to Bangalore.
Bangalore. So now case is pending before the Bangalore. CJM Bangalore Rural.
So you are happy. We have nothing to do.
No, my
You
lord.
send it, accept it,
Previously,
go to
previously, we have inquired about the matter. After analyzing the CDA record, it was came to the knowledge of the police.
tell us, approach your Bangalore counterpart and say, tell us what are the development in that inquiry. Anything has been found or not.
My lord, we will do so. My lord, kindly, if your lordship kindly permit me, after analyzing the CDR record of the accused as well as the victim, it was found that before 10 to 12 days before her missing, his missing both were in Bangalore.
Yes, my lord.
So the cause of action arose at Bangalore, my lord. And from the statement 164 statement of the parents, it was came to knowledge of the police that they were Bangalore at the time of her missing. And by the order of the learned court, the case was transferred to Bangalore. Two FIR in a
Nibas Mondol.
My lord, Nibas Mondal is his friend, my lord, the victim's friend, my lord. Both the person went
So
to.
are you keeping track about that investigation which is going on in Bangalore?
No, my lord, it's aged senior citizen, both the.
Maybe aged, but the thing is, how can we help you today?
No, let them file a
Investigation
report,
is coming, it has been sent on the basis of an order of the competent authority.
my lord.
Now it is in Bangalore. Now in Bangalore, what had been the status of the investigation? Have you
Difficult
taken
to.
any sort of information when it was transferred?
It was transferred in the year of 2019.
After that lockdown, my lord, kindly.
Now they filed this
report, my lord.
habeas corpus petition.
They have nothing else to say. They are showing the order of the learned magistrate by which it has been transferred to Bengal.
But a copy may be supplied, my lord, then my
Yes,
lord, I
yes,
can
my lord.
instruct my client to take positive steps, my lord. Or they can file a report, my lord. What is the progress of that case, my lord? Otherwise,
The
very
court-
difficult for my lord, the
How we
If petition here is not maintainable, how can we call upon them?
grateful, man.
a copy may be supplied, my lord.
Mr. Chatterjee, this is pass appropriate order. Come with an instruction as to what is the status, anyone arrested, anything
Well-
charges framed or not. What is the status? We will record that and pass this.
But my humble submission before your lordship, this is the instruction from Bangalore is very tough, my lord. And the case is pending before the learned court, not before the police. My lord, kindly see page number 20 and 21 of my report.
Page 20.
Of my report. It was received by the Court of Learned CJM Bengaluru Rural on 26 January 2019.
But if state found it's difficult for the petitioner, it is very difficult to further, my lord. Only at least, my lord, some remedy, my lord, may be given, my lord.
Pardon?
My lord, if state is finding difficult to take report from Bangalore, my lord, for the petitioner, it is, my lord, more difficult to take report, my lord, because
What people they will give, they will either say that we have completed our investigation, FRT has been filed. But you have to only on the basis of your petition, we cannot call upon any person. We will give you liberty so that you can take appropriate steps.
or immediate the report may be supplied, that report.
Serve the purpose. 2019 it has been said. Here in 2023.
This petition was paper primarily framed for forever. Really, ঠিক আছে? তো, Mr. Satan Saurana of product. Such also service. Samuel Kumar Kaur. Was missing order for 25th June 2017.
Data item.
এটা বলছি জানি না ওটা নিয়ে আমি জানি reported this incident to the local police. No
history.
But the police did not take any effective steps to recover the victim. The petitioner was forced to file a complaint under section 156 within bracket 3 of the code. Before the court, an additional chief judicial magistrate within bracket, treating the said complaint as an FIR. More Surat PS case number 156 of 2017, dated 11/10/2017. Under section 360, and stroke 365 IPC. And the investigating authority did not take any steps to recover the victim. And hence the petitioner has been forced to approach this court. Chakraborty, London additional public prosecutor submits that the victim was victim was Bangalore. And following the incident occurred in Bangalore, a specific case that it where where PS crime number 0438 under section 70 dated 10th August 2017 was started. This established that as per the order passed by the DCG, the pursuit of PS case number 156 of 2007 was transferred to the competent court of law. And appropriate to this as per order
দেখি যে ওই ম্যাট্রিমোনিয়াল কেসে
the investigation and inquiry of those cases are being done under the supervision of the competent court of Bangladesh. And hence the state of West Bengal is not in a position to the state of West Bengal. As produced by the state of West Bengal. Since non-competent court of Bangalore is insisting about the matter, and investigation or and an inquiry
in exercise of instruments. This would cannot shut. Take constitution with the appearance is called for it is in the picture and says according to the school. It is made clear petitioner with clear liberty to take appropriate steps before the competent court.
Great.
Yes, sir.
We have recorded the fact, we have exposed it up, we have given you liberty to take steps. This takes.
But I am productive. My lord, in this case, the victim girl was recovered today. And this is the recovered memo.
Where is
Memo.
she now?
She is now at police station and will be produced today before the Child Welfare Committee. Today itself she was recovered at 4:30 AM. My lord, kindly see the report.
4:30 AM. So when you prepared the report?
Thereafter, my lord. And they are raise allegation against police.
Not only police.
But in this case, I have some submission. If your lordship kindly allow me. Well, this is recovery memo, my lord. Separate sheet. Well, kindly see page number 3 of my report.
Who has prepared this recovery memo? Who has prepared?
Well,
The officer concerned is present.
yes, my lord.
Oh.
You is not present, my lord. Case has not been started, so inquiry officer is there, my lord.
Oh.
First, a case has been.
Which post he is holding now? The person who prepared the memo, recovery memo?
Sub-Inspector Vikas Sardar, one of the sub-inspectors.
Because of the sub-inspector. He does not know the recovery memo is required the signature of the witness. He does not know recovery memo, seizure memo.
Witnesses
Is trained or untrained? You are dealing with the body, a citizen of the country. When you are going to arrest, when he is going to seize, when he is going to recover, you are duty bound to take signature from the respectable person of the society. We are not given a better, we have so much discretion to deal with without any witness or such and such. One recovery memo you are producing in the High Court without having
There
any
should be,
signature from
my
any
lord.
witness.
My lord.
I don't believe it that you have been recovered. You have recovered, the victim has recovered. What do you do now? You don't know? When you are going to arrest, when you are going to prepare an arrest memo, I am to take signature from the respective person. You are taking custody of a body. Similarly, you are recovering this person.
Well, kindly see page number 10. Another document is there, my lord.
Who is Ombika Silwar? Who is Ombika Silwar? Now the case originated in Sikkim.
Yes. My lord.
Your daughter,
My lord, Ombika Shasman, my lord, that is, my lord, he is the informant, my lord, upon whose, my lord, the complaint, the case was started.
you didn't know that a case was pending in Sikkim.
Yes, my lord, they went there. My lord.
My lord, I have been, my lord, communicated, my lord, because the maternal uncle of the victim girl, my lord, take the custody, my lord, on that, my lord, this area. And thereafter, my lord, kidnapped.
Are you deciding where was your daughter? She was with you or she was with her maternal uncle at Sikkim?
No, my lord, at the time of, my lord, when this, my lord, the accused person was continuously, my lord, threatened, my lord, just to, then, my lord, I just sent.
When did she leave your house?
My lord,
She was sent to Sikkim.
my lord, my lord.
Because she was being threatened.
My lord.
So when did she go there? To your maternal, to her maternal?
My lord, I have made, my lord, this my apartment, my lord, kindly. My lord, page number 5, my lord. My lord, page 5, my lord, on 18 June 2023, my lord. My lord, my lord, 18th of June.
পুলিশের কাছে he has not produced anywhere.
একটা চিঠি পেয়েছিল লিখছে চিঠি পেয়েছিল
My lord, another my lord things, my lord, I just want to see, my lord.
চিঠি পেয়েছিল দেখুন হ্যাঁ কই কই
Where did you state that?
My lord, page number 5, page number 5, my lord, 18th of June 2023, the daughter of the petitioner along with her maternal uncle went to Sikkim.
yes
My lord, one thing, my lord, this is, my lord, the original birth certificate and the Aadhaar card of the victim girl. And my lord, kindly, my lord, page 32, the accused person, my lord, manipulated a, my lord, false, my lord, birth certificate, my lord, just protection from the, my lord, the law, that is that this daughter has been attained the majority. And my lord, what is, my lord, how can I collect, my lord, this fake, my lord, this, my lord, the Onchol Sabhapati of my lord, Gram Panchayat, my lord, supplied me this type of fake documents, my lord, through WhatsApp chatting. And my lord threatened me that your daughter is attained the majority, so she will be protected by the law. That is, my lord, the statement of the, my lord, the Onchol Sabhapati. My lord, that is, my lord, the Onchol Sabhapati, my lord, by, my lord, chatting, my lord, this type of. And not only that, my lord, I have, my lord, on page 15, by forcefully converted the religion of my victim girl from the, my lord, Hindu to, my lord, the Islamic, my lord, Syria.
my lord they have the knowledge
is
that
also, my lord,
another case was started before another police station and they are trying to start another case before this police station, my lord, but this is barred under the article 20 within bracket 2 of the Constitution of India, my lord. 2 FIR in same cause of action is not permissible, my lord, but police can inquire and after the inquiry police recovered the girl.
We are not satisfied. And what you have produced before us, it leaves doubt as to whether at all she has been recovered. That is what
My
my
lord,
brother
my
was
lord,
saying.
I am paying apology on behalf of my client regarding this memo, the recovery memo, my lord, but other documents is there, my lord. Kindly see the annexure of my report.
We will not.
Page 10, my lord.
Accept করা যায়।
My lord, kindly fix another date. I will produce the report of CWC also.
You will produce today
Today, my lord.
before the SCGM or
ACGM, ACGM.
SCGM.
Yes, my lord. Arambagh.
Your investigating officer is here.
No, my lord, there is no investigating officer. Inquiring officer is there, my lord. FIR has not been.
It was in Sikkim.
Sikkim, my
Where
lord.
was in Sikkim?
Yes, my lord.
You tell your officer.
My lord.
We are keeping it on that day. One single threat from the private respondent to this person, we will take appropriate steps against your
My
inquiry.
lord, my lord.
If he receives one single threat, if the parents receive one single threat from this respondent number 7, we will haul up your office.
My lord. I will inform, my lord, but I am disputing their submission, my lord.
Their submission dispute you have recovered. Your recovery is not in the formal procedure. You are producing it before the magistrate. Magistrate will look into this issue.
My lord.
And you come and tell us on the next date.
My lord, kindly fix it at Monday, my lord. I will produce at Tuesday.
Where is your complaint today?
My lord, kindly see the complaint. They never mentioned that another case is pending. They suppress it. নতুন কমপ্লেন করেছে না
Have you asked your officer, have you registered it as an FIR? Have you started any case on the basis of this complaint?
My lord, I have not seen the complaint, my lord.
You did not take it.
No, my lord, there is no provision to start another FIR, my lord. As
Why?
per,
Oh, he cannot say that I am being threatened and go to the local.
my lord, this is the, I have never
Ask
seen,
your person. এটা ওকে
my
দাও।
lord, kindly. এটা কবে দিয়েছো?
আরে ওই চিঠিকে কোর্টে আসে তারপর থেকে ঢুকতে পারছে না।
26 নয়।
এদেরকে ঢুকতে দিচ্ছে না, অঞ্চল সভাপতি নিজে
Learned advocate appearing for the
My lord,
petitioner.
police will take steps, my lord.
He learned
But
you
this is,
better do it. Better do
my
it.
lord, this is not in petition.
Service complete or not?
My lord, service has been complete. The accused person, my lord, as per the current status, my lord, item received, my lord. It is
When?
When did they receive?
received, my lord, on
29th,
29th of
today. My
I
lord,
your evidence
my lord, I will.
course of this day.
I will.
Evidence of service filed by the petitioner the case on record. Learned advocate appearing for the petitioner submits that the petitioner's minor daughter.
Take it back.
What is her age?
My lord, right now, my lord, 15 plus, my lord. 15 plus, my lord. 15, my lord.
That the petitioner's minor daughter is missing since.
18th of June, my lord, 2023.
18th
18th of June, 2023.
of June 2023, and appropriate steps have not been taken by the police authorities to recover the victim girl. He further submits that the private respondent number 7. Where is your complaint? Complaint you have filed against whom?
Complaint.
পঞ্চায়েত প্রধান নাকি?
I'm actually reading.
Usiur Rahman.
Oshiur Rahman Khan.
Is respondent here?
Yes.
My lord, respondent number 8, my lord, in this petition.
He further submits that the respondent number 7
Respondent number 8, my lord.
respondent number
8.
submits that the respondent number 8 is repeatedly threatening the petitioner. Repeatedly threatening the petitioners. As we had preferred the present petition. Stop. A complaint to that effect was also such fact was also intimated by the petitioner to the respondent number 5
5.
on 26th of September 2023, and even thereafter the police authorities have not taken it.
My lord, it was received today, kindly mention it.
No.
Mr. Chatterjee learned additional public prosecutor prays for an accommodation today to avail necessary instruction. This is the matter for further consideration on 6th
My lord.
on 6th October.
My lord. 6th October.
সিকিম থেকে
এদের অ্যাকচুয়ালি মেয়েটাকে রিকভারি ইচ্ছে নেই।
Stop. The respondent number 5. You are the respondent number 5, no?
My lord,
I will direct your officer in charge. Respondent number 5 is directed to ensure the safety and security of the petitioner, ensure the safety and security of the petitioner and his family members in the district. So, state filed a report, he said, the said respondent number 5 shall also file a report before this court on the returnable date as regards the steps taken on the basis of the complaint lodged by the master. Mr. Chatterjee, ask your officer that not a single threat should.
My lord, I will.
And on that day, what if you are producing there, we are returning your.
I have already taken, my lord.
You come with the order of the magistrate and.
Now CJM will think whether he will send the victim or he will such and such. CJM will think. CJM or CJM will think.
Grateful, my lord.
And for the petitioner, serve the notice upon the learned advocate.
Yes. Yes.
My lord, petitioner appeared in the interview and he was passed the interview. He was passed the interview and directing him to appear before the authority. And that notice is postponed. Thereafter, and the first list, the petitioner's name was appeared in the merit list of 43 out of 179 post vacancy.
Where is the employment notification?
His name was appeared in the annexure, which is annexure A.
29th of March 2018.
2018.
That was the advertisement. Now
But
you apply.
he appeared.
How many persons? Only one petition.
Then
Obronil Kaur. He appeared.
he appeared.
Then what happened?
And his name was appeared in the first panel list as serial number 39. 38 serial number out of 179 posts.
38.
38 serial number. Go to page.
Page.
Serial number.
What is this page 33? Page 33, what is that?
Serial 38. Page. They are given notice, my lord, page 33. They were application as per enters the list, medical officer, and attested photograph, and directing him to appear before the authority.
You were directed for verification of documents.
Yes, my lord.
Then what happened?
Then, my lord, his name was appeared, my lord. Next page, my lord, page 35.
Hmm.
And then the merit is here, name is appeared,
This is not a merit list.
is a panel, my lord.
This is a list of candidates who were called for verification.
Yes, my lord.
So he
Call
was
for-
called for verification.
Call for verification and choosing the posting of the post. Yes, my lord. As per,
Page 35 reporting date is 19th of July. And you are at serial number 17.
Yes, yes.
yes,
You are at serial number 17.
Yes.
yes, 17.
That was your number.
Yes,
1022.
What is the number? Why you have
original letter. Yes. Original, actually.
Yes, then you were called for verification. Then what happened? Then came the notice of counseling on 1st March 2019.
Yes, my lord.
Now, after 1st March 2019,
They are postponed the said date.
what is page 37? This is the list called for counseling. Where is your name in this list? One zero three. You were called for counseling. Then due to honor merit comes posting. And
My lord, page 36, my lord. They are called for merit, merit choice posting counseling as for the purpose of choosing the posting. Page 36.
page 33 is the notification.
Yes, my lord.
Now, after notification, you were called for verification of documents.
Verification of documents and choice of posting also, my lord.
That is page 36.
Yes, my
Now,
lord,
after
36.
that, you were called for counseling.
Yes, my lord.
Now, in the counseling, your name list was there, page 37.
Yes,
Then that date was cancelled.
Cancelled.
And the rescheduled date was fixed.
repeat.
Then what happened?
Then my name is appeared in the waiting list. Once waiting list.
Where is that page?
Yes, sir.
Yes, 131. Waiting panel 40.
Page 40, my lord. My name is appeared in the 131.
Yes.
But earlier panel is not cancelled.
Which is the earlier panel? Which is the earlier panel? Tell us. Page 37. Kindly come to page 37.
Yes, my lord. Wait, wait. 1022.
These all do you appear for state respondents?
Page 31, page 31, last but one. My name is appearing.
Page,
37. The column on the last but one.
we have seen that.
Yes,
We have seen that. Now thereafter, page 38, you were called for. Page 39, you were called for counseling again.
yes, my lord.
Then you appeared.
Yes, my lord.
And what is page 40? Page 40 is the final list.
They are directing me to appear and they are attached this circular, this list where my name is waiting list. This is the page 40, 131 my name.
What is the wrong in that? Page 37 was the list of the candidates who were called for counseling.
Yes, my lord.
After counseling,
Counseling has not been done. They are postponed the counseling. That is the first counseling. First counseling was they are postponed.
page 39 is the second counseling.
Yes, my that is this
Page
list.
39 is second counseling.
Yes, my lord.
Then what happened?
On the second count, The page 13 is the originally council, they are called for counseling. But my name is appeared from 38 to 131.
That is because you were not coming within the marks.
No, no. I have meet with all of date. They are postponed the meeting. I have not.
They postponed the counseling.
Yes.
After counseling was held,
Yes, madam.
page 40 was published.
After counseling, I am not appearing. They are not communicating later. They postponed my counseling.
Page 39 is the next date of counseling, 28th June, 1st July, and 2nd July.
Yes,
Did you appear in that counseling?
yes. But my name is the 131. They are not allowed me. They are not allowed me. They went to the office, but they are not allowed. Because my name is waiting list.
After
I am challenging this. I am challenging this notification, my lord.
Counseling type panel বলছে নাকি? For counseling is the
page 39 counseling এর date হতো। এর আগের
notice for counseling.
সেটাতেও appear করলে বুঝতে পারছি না।
Second. P6 meter. P6.
Who is your advocate for state?
Arjun Ray
Arjun Ray Mukherjee, I have served the notice, I have filed the affidavit of service also.
Arjun Rai Mukherjee
Yes, my lord.
was just now here.
I kindly see in the page 38, my lord. They are postponed the first meeting, first counseling.
No, you
Page 30.
guys come to page 28. What is the process of recruitment? First, merit list would be prepared on the basis of the score obtained in the examination from secondary up to last examination. Okay. On the basis of the marks obtained in those examinations,
Council was not held.
one merit list will be prepared.
But on the what basis?
You are in this matter.
Yes, my lord, on the last occasion.
Last occasion.
The matter was, may I indulge my lord with your kind leave, may I indulge?
Notice the issue.
Notice the submission.
Thereafter, merit list prepared. Thereafter,
No,
next-
yes, my lord, no council has been done.
Listen to what my brother is saying.
thereafter your testimonials will be verified. Then one list will be prepared for what? For verification of original testimonials and Bengali test. You are called for that counseling in which your original testification was required to be verified and you have to appear in Bengali test. It is not that the final merit list was prepared or final panel was prepared and your name was included in the panel.
The first conference is not held. Yes, deferred deferred that conference.
My lord, with your kind leave, may I submit one thing? With your kind leave, may I submit one thing, my lord?
No. One person is happy.
বলছি তো না।
Postpone, তারপরে
postpone পর page 40 যাবে। এখানে ডান দিকে কলমে page 40 তে বলছে গল্পটা রিপিটমেন্ট করছে নেই।
নেই। ও,
Mr. Mukherjee, please
So
take
that,
instruction.
extremely sorry, my lord. Your lordship, kindly fix it on the next week, any day next week, my lord, I shall assist your lordship. But I'm extremely sorry, my lord, I missed the list, my lord.
But they're not filed any affidavit also, personal direction.
Once
Yes, my lord.
court said that the list which has been prepared, we do not understand whether the report, any document was produced. Court observed that he was secured less months, he was at 131, appointment were made up to 89 or 90.
Yes. My lord, we perhaps we produce the entire records, my lord, pertaining
Do
to
not
this.
know.
Very well, my lord, I,
So that and
Very
we finish it.
very,
Tell us when can you
my
come?
lord, Wednesday, my lord.
All right, Wednesday,
Grateful.
Wednesday you get the record.
Yes, yes.
All
Or my lord, kindly make it Friday. In the meantime, my lord, I shall ask the officer to.
right, Friday.
Grateful.
Friday.
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 6th of October, my lord.
6th of October. Please bring the
Yes,
records
yes,
and
certainly,
take it up.
certainly.
Do you have a copy of this?
A writ petition, my lord, I have a copy.
লাস্টে আমাদেরকে কাগজ আনতে বলেছে। Item 10, my lord, I am for the appellate. And on last occasion on 14th of September, two matters were taken up together. And order has been passed in both the matters, but one of the matters is not appearing in the days list. Your lordship sees the order dated September 14, 2023. And both involve the identical point of law.
What is the other one?
The other one is appearing,
Other one is, my lord,
MAT 484 of 2020, another is
MAT 519.
519 of 2020.
And this is
One is disposed of, the other is also.
same. Lordship, আমাদেরকে এই কাগজগুলো প্রডিউস করতে বলেছিল, এটা ঠিক আছে? এমনি আজকে হিয়ারিং করে দেওয়া যাবে।
Huh?
Lordship has made both the matters part hard.
September. অন্য ফাইলটা Oh, it is that appointment matter.
Yes, Alia University, whether, my lord, approval of AICT is required or not.
We matter. Tomorrow it will appear. Tomorrow.
Tuesday.
Tuesday,
Tuesday.
not Tuesday. Tuesday.
Both the matters.
Kindly take it on Wednesday. It is
Note করেছো?
বলো Tuesday হবে না।
kindly Milad take it on Wednesday. ঠিক আছে।
বুধবার দিনকে তাহলে
Yes. কেন করে কি হবে?
স্যার 4 তারিখ থেকে
ওটা হবে না? বুধবার থাকবে। One formal line of the order can be passed.
it is a ought to have been moved in both the matters. Yesterday was a holiday. Na?
That I only one formal line at the instance of my Lalit Junior I am submitting.
Both the matters are not beyond the Mr.
ঠিক আছে, চলো।
এখানে থাকে। বিয়ে করতে হবে। রেখে দে এমনি।
I'm for the number one.
Can it wait after the vacation?
My lord, she aged about 55 years, my lord.
Yes.
It's matter of family pension. It will be kind enough any date. My pre
Because
puja
from 9th, my brother won't be there. Circuit bench meet up.
before 9, if possible, if my
What is the matter about?
widow daughter's pension.
Widow daughter pension.
We don't
Family,
know.
family pension.
Acha, acha.
That's it.
We heard it, Mr.
Yes, my lord.
I said something, my lord. Anyway, my lord.
Checked up. Have you checked up?
Yes, I have checked up.
Last occasion, my
Mr.
lord.
Dotto is leading me. He's coming. Anyway, madam.
They- What happened? You will do it, Mr. Jana?
My lord, yes, no. The petitioner, my lord, the writ petitioner respondent, my lord, herein is the daughter of deceased employee who was the employee of Shama Prasad Mukherjee Port, Kolkata. The deceased employee retired on 1st March 1979.
It is that married daughter,
Yes.
that case.
Deceased employee retired on 1st March 1979.
Yeah, just. Or 1st March
1979.
79.
9.
The Chittoranjan.
Chittoranjan, yes, my lord. Because these dates are very important. That's why, my lord, I am giving some dates first.
Chittoranjan retired.
Retired.
Yes.
Then Chittoranjan died on 21st August 1997.
21st August
1997.
97. For that time, he enjoyed pension.
Yes.
Next.
Then, after the death of the Chittoranjan, my lord, the wife of the Chittoranjan was getting family pension from 22nd August 1997.
Then who is Geeta Mond?
Geeta Mondal is the wife of the deceased employee.
Not the mother.
No. Yes, mother of the petitioner. Mother of the petitioner.
Oh,
Geeta Mondal is the wife of the deceased employee Chittoranjan.
Acha, acha. So, Geeta Mondal means the widow of the deceased.
Correct. Correct.
Widow of the deceased is Geeta.
Geeta. He was getting pension.
Yeah, just a moment. Geeta was the widow. She was getting pension from
22nd August 1997.
Geeta got family pension.
Yes.
Yes.
কবে মারা গেল গীতা মন্ডল?
Page 58 is the order impugned.
No, man.
5th of March 2021 is the order impugned in the appeal.
Yes, ma'am. 7th June 2022. Page 66.
Of stay application page
66.
The application page 66.
Now, earlier you had asked to consider.
Yes. I am coming, man. I'll give some date thereafter. I'll come to that order thereafter.
Tell us.
কে কবে মারা গেল? গীতা মন্ডল।
Mother died on 3rd November 2015. Mother, 3rd November 2015. Mother died.
Geeta Mondal, the mother, while getting family pension, she died on 3rd November 2015. I mean, নামে কে বলো? ঠিক আছে। 3rd November, 3rd November 2015.
Yes. Now thereafter, the petitioner
Now,
got
now,
married.
the petitioner married on,
September 2000.
no, 29th September 2016. The petitioner being the daughter of the deceased employee married with on 29 2016. I'll cause your moment, my lord, here.
Yes.
2016. So the petitioner was entitled to family pension as an unmarried daughter till 29th September 2016. Till the date of her marriage or remarriage, she is entitled to pension or widow pension, whatever may be. Either marriage or that within that time he has to apply for that. He has not applied for family pension. No. Could not have applied because mother was there, but I mean, family pension was received by the wife.
Now, after the wife, it will go to the unmarried daughter.
I'm coming, man. Entitlement. I'm on the entitled.
We understand, but why, Mr. Dotto, you are saying she could not have applied?
Because when the mother was alive, the daughter could not have applied.
Mother died on 3rd November.
Yes.
And she got married on 29 September 2016.
Yes.
So she could have applied in between 15 and 16. সেটা তো বলতে হবে।
Yes, yes. That she is entitled. She can get that subject to application.
Yes, what else? What you are saying?
Then the husband of the writ petitioner died in 31st May 2017.
No, 7 June 2017. Husband died.
Died on 31st May. 31st May 2017. Husband of the writ petitioner passed away May 30, 2000. Page 4, para CE.
In the earlier order, it is mentioned 7 June 2017. Page 58, the earlier order.
Anyway, this is my last instruction.
Page number 59.
Oh, 31st May.
Yes, my lord.
No, I have said in my paragraph, page 4.
All right, 31st May 2017, husband expired.
After the death of the husband, when the husband died, my lord, I have SM court has no connection with the husband of the writ petitioner because after he got married, he detached. He could have applied after the death of the mother within that interregnum period. He or she is entitled to that period only. Family pension. Now, your lordship, kindly see.
কনফিউশনটাই তো আগের দিন উঠলো।
Disposing on Gita was enjoying her until her date on 18th March.
18 আবার 58-এও করছে যে 18 মার্চ। ও এসে বলতে চাইছে যে মা মারা গেছে 3/10/2015, কারণ এইখানে প্রথম পাতায় এই অর্ডারটা লিখেছে
3/11/2000।
এইখানে 3/11, sorry।
So you place the order into facts are there.
The facts are there,
So,
but impugned order is at page 66, madam.
Yes.
The petitioners claim to be the widow daughter of late Chittaranjan Mondal, a former employee of Kolkata Port Trust, now known as Ramaprasad Mukherjee Port. The petitioner says that the father died on 21st August 1997. After the death of the petitioner father, the petitioner mother was receiving family pension. According to the petitioner, her mother died on 3rd November 2015. The petitioner was unmarried and aged about 29 years when her father died on 21st August 1997. The petitioner was also unmarried
when her mother died on 3rd November 2015. Her age at that point of time about 47 years. The petitioner as an unmarried daughter on the death of the mother became entitled to claim family pension, provided she had no earning of his own as she was by that time over 25 years age, as per the circular of KOPT dated 25th September 2012. Well, that's why I want to show this circular. 12. No claim for family pension was made at that point of time. Subsequently, the petitioner got married on 29th September 2016 to one Amit Mondal. The said Amit Mondal died on 31st May 2017. The petitioner therefore became a widow daughter of the deceased employee. The petitioner also claims to be a handicapped lady without earning of her own. That is, handicapped is a different issue, pension is different issue, widow pension is different issue, as per the various circular. In the previous writ petition filed by the petitioner being WPA number such and such, an order was passed on 5th March 2021, disposing the writ petition. In the said order, it was recorded that the petitioner's mother, Geeta Mondal, was enjoying family pension until her death on 18th March 2019. In view of
This is the date creating problem.
Yes.
discrepancy on the date of death of the petitioner's mother, the petitioner saying his mother died on such and
Let's
such.
forget about this. Read what is there.
Mother, the respondents were directed to produce all available record pertaining to the petitioner's father. The records have been produced. I do not find from such record the date of death of the petitioner's mother. In absence of such document, it is for respondent to explain till which date the family pension was given to the petitioner's mother. This explanation is not available from the record of the produced. Well, the petitioner is admitted that when his mother was getting pension, he has
You have given pension, you don't know his date of
sometime
death.
old record, it may not be available. That's why could not be produced. Well, anyway, on that
Is the court's desire to see the records? How can you say that you cannot produce? You do not maintain records. Only on that basis the court has directed that I am not being able to ascertain when is the date of
we are
death.
not denying the date of death.
Mr. Jana,
we are-
records are yours.
The records are yours. It's a case of a death.
Can you produce the records or not?
Whatever the records I will produce. I do not know. Malab, this is a change brief. I was not there at that point of time on the writ petition.
Then now come to page 68. What is the court's finding? I direct KMC to grant family pension.
Then considering such and such, considering on behalf of KOPT submitted that on having married, the petitioner has lost her right to claim family pension with effect from 29 September 2016. So this is the circular. The date of marriage is admitted 20 September 2016. The petitioner therefore is not entitled to claim. Considering all this aspect, I direct the respondent number 2, being the chairman KOPT, to grant family pension to the petitioner, subject to being satisfied that the petitioner is not receiving any social security benefit, family pension, deceased husband, and see you has
Where
no
is your circular of 25th September?
circular is my lord at page 63. ঠিক আছে। 63. Unmarried daughters, paragraph 2, second column.
যদি বিডোর ডটার থাকে তখন এটা আনম্যারিড ডটারটাকে বিডোর ডটারের মতো Yes, where is that circular?
Circular page 63, my lord.
63.
3. Para 2, column second box.
unmarried daughters.
Then you
including
first,
widow.
in terms, in
So
terms,
on the date of the mother's death,
And-
she was beyond for 25 years.
yes. 25 years, 47 years when he applied at that point.
Or till the date she starts earning, or up to the date of her marriage, or till the date.
Lordship, can you see the circular, intention of the circular? In terms of BWNC settlement, bipartite settlement, dated 19 January 2010. Subsequent clarification received from Indian Port Association.
ও বিয়ে করলো হচ্ছে, ও বিয়ে করলো হচ্ছে 29 সেপ্টেম্বর। তিনটে রাইডারে পাবে, এটা হচ্ছে 25 years or up to the date of her marriage or till the date, whichever is earlier. মানে এখানে the earliest is 25 years. কেননা ও বিয়ে করেছে বিয়ে করে ফেলেছে না, সেটা অ্যাডমিটেড। তার মানে যেদিনকে 25 years ওর ওভার হয়েছে, সেদিনকে ও আনম্যারিড ছিল, তখনই ও নট এন্টাইটেলড। So your case is that on the date of death of Gita, she was admittedly beyond 25 years.
Number one.
Number one. Second is first rider, she does not fulfill. Second rider, she marries.
Married.
In 19, she got married on
Married on 29 September.
September 2016.
Once
So,
she married, once she
Why
married.
you are saying that she could have been entitled from the date of her mother's death till she remarried?
Remarried.
কি করে?
Circular.
At that time, she was 47.
47, right? If the age is 47, she is not entitled. Not entitled. At the worst case, I was saying that. At the worst case. Second paragraph of the circular.
Circular করে দিয়েছে, দুটো condition করে দিয়েছে। ওই dependency confusion হচ্ছে, whichever is earlier.
আচ্ছা, এই বিয়ে করলো উইডো ডটার হয়েছিল, ডটার কি তাহলে
ডিসেন্ড করে কোথায় পেলাম, এটা কোথায় আছে? ও
সেকশন 5
সেকশন 5 কত আছে?
কেন confusion হচ্ছে?
সেকশন 5 the page
যে চিল ম্যারেজ
এই তো
আর ম্যারেজ তো সে উইডো ম্যারেজ খুলবে দিক থেকে।
Oh, my lord, your lordship asking for
she attained 25 years.
Whichever is earlier.
Whichever is earlier.
আর সে যদি বিয়েও করে থাকে, সে বিয়ে করল on the date of death she was unmarried. কিন্তু যেহেতু she was an unmarried daughter, ওনার পেতে পারতো till she attains 25 years. যদি 25 বছরের উপরে তাহলে সে পেতে পারে। বিয়ে করে ফিরে এলো, বিয়ে করে
ফিরে এলো।
When did she apply?
she applied 2019. She applied on petition application of family pension 26 June 2019. 2019. My lord, your lordship was asking me the date of death.
26
June 2019.
19. My lord, lordship, can you see page 45? The date of death certificate is there. Lordship, troubling your lordship about the death of the Gita Mondal. That is at page 45.
That was not troubling us, that was troubling the learned single judge. Because the judge said that upon
Lordship, can see that record. You are asking for produce the record, page 45.
Two courts have observed the date of death was 18th March 2009.
No, 31st, my lord, 3rd November 2015. Here date of death.
Come to page 15.
The 45 is the date of death certificate. 45, page 45. Page 45, left column. First one is the name Gita Mondal, date of death. 3rd November 2015. Date of death is here. This is the record. So record to court record. And which is the part of the writ petition.
Reason daughter the page 61 এ pass করেছে এটা তো কিন্তু date of death So your contention is that on the date of death, at best, it can be construed that she was dependent.
Dependent.
But at that time, she was over 25.
Over 25 years.
But Mr. Jana, suppose father dies in a case, all married or unmarried daughter, suppose there is no wife, no widow. In that case, what will happen? You will restrict it to 25 years.
Up to 25 years. Or till the date of remarriage or marriage. That is column 2 of 63. Page 63.
Oh, here,
that means in case of unmarried daughter also, you will give up to 25.
25.
Or till marriage.
Or till she marriage or remarriage.
No, it is not. As and when he will marry, she will marry, his entitlement will cease.
She's correct.
No, you are saying this on earlier occasion, but you have extended the benefit the widow.
Widow.
As and when he will be widow, his entitlement will come back to you. Have God.
With the best of this.
Suppose he got married in 15 years. Thereafter, he became widow in 17 years. He came back to his father's house. Started being dependent, he started living.
Then, my lord, you will not.
He will get up to
Then column 2,
years,
column 2, lord. Page
8 years.
Yes, 8 years, page 63, as per circular.
25.
With the best of respect, that is not the circular, my lord. But kindly read the circular as a whole.
are you disputing these dates? You are not.
No, I'm not disputing any dates, my lord. I'm yes, my lord.
This is my case. Oh, another thing, my lord. This, my lord, your lordship.
The entire circular, we are just thinking, Mr. that suppose I am the employee, my wife predeceases me. Then if I retire, my heirs will become entitled. Suppose I have a son who is a married son, he does not become entitled.
Up to 20 or 21 year, 25 years.
Saying this 25-year slab is applicable to all unmarried daughters, in the sense even if the widow is not there. Mr. Doctor?
Well, the intention of the circular, as I could gather, is whether in the case of a daughter or a son, the outer limit is 25 years.
Yes, what I am saying is,
Yes.
suppose there is only one sole claimant. Widow has expired. If the sole claimant is an unmarried daughter, will her family pension cease after she attains 25 years?
Yes, it should be. Kindly take me at the second part. The left-hand side column says unmarried daughters. So
Yes.
I put her in the bracket of an unmarried daughter. As on the date, as your lordships were giving example, as on the date of the death of the father, with the mother predeceasing the father. Then can you take the right one? Up to 25 years of age, or till the date she starts earning,
Sorry, no.
or up to the date of her marriage, stroke remarriage, or till date, whichever is earlier.
No. Circular, read the circular.
Yes.
Subject matter of the circular.
Circular was issued with the subject heading grant of family pension to the dependent parents and unmarried, divorced or widow daughter beyond 25 years. of
Yes.
age.
Yes.
Why circular was issued? For this purpose. Now, earlier circular was para 2. Then what circular says? Come to page 2.
Yes.
Page 2.
Middle portion.
Yes.
Bullet portion.
Got it? Family pension to widow and divorced daughters is admissible irrespective of the fact that divorcee or widowhood take place after attaining age of 25 years.
Right.
Or before.
Right.
That means the benefit has been extended up to 25 years has been withdrawn. It has been extended, benefit has been extended beyond 25 years.
Now, my lord, with all humility, my lord, first is, my lord, the heading itself, my lord, as your lordships have always held, that the heading, even of a section, is not the determining criteria. Number one. Number two is, my lord, the bullet portion, my lord, which my lord has been pleased to, my lord, read out. Kindly, see, my lord, if I may read it, my lord, in my own humble way. Family pension to widow, stroke divorced daughter. Now, the juncture has to be ascertained first. When does somebody gets entitled to a family pension? The juncture is, or the event is, the death of the retired employee. That is the event, like a taxing event. So this is an event where, my lord, somebody acquires a right to get family pension. Therefore, my lord, keeping this in mind, my lord, may I read further? Family pension to widow stroke divorce
No, Mr.
daughter.
Dotto, read it from the beginning.
Yes,
First
sir.
paragraph 2 is relating to category 1 and category 2 is paragraph next category. Category 1 is in respect of retired officers and retirees of class 3 and 4 post.
My lord is reading, my lord, from page?
Page 63,
60.
paragraph 2, category 1.
Category 1, yes, my lord.
Applicable both for retired officers and retirees of class 3 and 4. He was working in
3.
Oh, he was in 3. Then category 2, applicable for recoveries of group CD irrespective of their date of retirement and for retired officers who retired after
2007.
2007.
Here he retired before that. He has retired in 1979. Therefore, category 2 will not apply. Category 1 would apply.
No, applicable for retirees of group CD irrespective of their date of retirement.
Yes.
And that is for retired officers who retired on or after
1/1/2007.
1/1/2007, yes.
Category
3 or C?
category 2 তে আছে।
Category হচ্ছে retired, both are retired class 2 এটা।
Confusing.
Chittaranjan Mandal was in which post at the time of his retirement?
From the petition,
Paragraph 3, but
The three,
only employee, but class is not mentioned.
yes. No, the class is not mentioned, but acha, the application.
Applicable both for retired officer and retirees of class 1, class 4. That means who already retired on the date of issuance of the circular.
And retirees. মানে রিটায়ার্ড অফিসারদের এবং ওয়াই রিটায়ারিস মানে 3 and 4 এক্সটেন্ড করতে
Designation blank আছে।
রিটায়ারিস আর ইররেসপেক্টিভ অফ দ্যাট and
ওটা
তার মানে
address,
ক্যাটাগরিতে এ আসছে
pension case, pension roll number,
ডেট অফ
so and so.
As well as beyond 25 years of age. According to above orders,
কোন ক্যাটাগরিটা বলা নেই।
extend the
Instruction given to the
criteria for grant of application stand as below, applicable to both retired officer or retired class 3 and class 4 post. এটা হচ্ছে এইটা retired. Applicable to the retired 2017. Chittaranjan retired on
না না এটা হচ্ছে দেখো সেটা হচ্ছে এক্সটেন্ড করার জন্য একটা ডিসিশন নেই বিয়ন্ড 20 এবার বলছে আগের যেটা ছিল 25 ইয়ার্স প্যারাগ্রাফ 2 ক্যাটাগরি 1 এবার ক্যাটাগরি 2 নতুন ইন্টারভিউ
category.
আচ্ছা,
দুটো ক্যাটাগরিকেই বললো ফ্যামিলি পেনশন ইজ অ্যাডমিসেবল ইররেসপেক্টিভ অফ দি ফ্যাক্ট Mr. Dotto,
yes sir,
is subject to correction. What my brother pointed out that nomenclature is not the. Now
correct,
kindly come to the first paragraph, last line.
yes,
Or I read, in terms of settlement of 2000 and subsequent clarification, and in terms of government conveyed such and such, it has been decided to extend the benefit of the two dependent parents of the pensioners as well as dependent daughter beyond 25 years.
yes,
So for extension beyond 25 years, what was the earlier position? Paragraph 2, category 1. In respect of category 1, it was 25 years. In respect of category 2 also, within the box, unmarried, widowed, divorced, whatever is was gone. Now taking those two categories, now the decision is the bullet mark.
Yes.
Family pension to widow divorced is admissible irrespective of fact that divorce widow takes place after the attaining the age of 20.
yes.
So her entitlement was there on the date of death of her mother.
Now, my lord, may I say this, my lord? Please consider, my lord, the circular or the entitlement, my lord, is to be judged on the basis of the date of the death. Now, coming back to, my lord, this part which your lordships have been pleased to, my lord, read out, family pension to widow, stroke divorced daughters is admissible irrespective of the fact that the divorce stroke widowhood takes place after attaining the age of 25 years or before. So, my lord, your lordships, my lord, or my lord, the application of the circular is based on the status which is prevailing on the date of death. A status later on acquired, in my very humble submission, will not be guided by this. Well, there can be so many situations.
No, but what about the interregnum then?
Yes,
At best, then she becomes entitled to the interregnum portion. Date of mother till the date of her remarriage.
Millard, here is a case, Millard, where
Yes,
Yes.
date of mother
Millard,
was,
date of mother is 3rd of November 2015.
at that time, the lady was unmarried. She
Yes.
married on 29 September 2006.
The
Then if we
15
go
to
by
16.
your contention, then also she becomes entered during that.
Yes. Now, Millard, here, Millard, the question would be, Millard, In that case, my lord, reading the circular in favor of the petitioner, two things would emerge. Number one is, my lord, assuming that she is entitled from, my lord, 3rd of November 2015 to 29th of September 2016 at the best. Number one. Number two, which is most important, is where the entitlement would acquire, my lord, subject to an application being made to such an effect.
You should not be so cruel to persons. You should not be so.
He has not made any application.
Where the problem with this, my lord,
কি দাঁড়ালো?
দুটো একটা হচ্ছে যারা রিপেয়ার
সেটাই তো জজটা বলতে যায়।
2007 আগে
ডিসিশন হচ্ছে
কেন না কবে থেকে ডেট অফ ইফেক্টটা দেয়া হবে?
এই যে
ক্যাটাগরি 2 এর ডেট অফ ইফেক্টটা হবে হচ্ছে 1/1/2007 থেকে, আর ক্যাটাগরি 2 এর হবে ডেট অফ সিজার থেকে, কবে থেকে তারা মানে সিজ হলো তবে থেকে। মানে ইফেক্টটা ডেট অফ ইফেক্টের জন্য এই দুটো ক্যাটাগরি ভাগ করা হবে।
ফার্স্ট
All will get beyond 25, কিন্তু এবার কমপ্লিট ডেট তাদের দেওয়া হবে, তার জন্য এইখানটা ভাগ।
কোথায় ভাগ করা হবে?
এই যে এইখানটা দেখুন, ক্যাটাগরি 2 পাবে
1/1/2007
থেকে, আর ক্যাটাগরি ফ্যামিলি পেনশন ক্যাটাগরি হ্যাঁ ক্যাটাগরি 1 এর ক্ষেত্রে যেদিন থেকে তোরা সিজড হয়ে গেল।
এটা কোথায় ডেট দিল?
এই যে have ceased to
family pension to the family members covered under
আমার এখানে একটু
two shall be payable only for the other eligible family members in category 1.
Have ceased to be eligible to receive family pension and there is no disabled child.
Circular itself is very
yes, yes.
কেননা দেখো
Category family pension to the family members covered under category 2
না সেটা না,
shall be payable only after the other eligible
এটা হচ্ছে entitlement of category 2.
era category 1 have ceased
To be eligible.
to receive family pension and there is no disabled child and receive payable only after.
But that is pertaining to category 2.
2 হ্যাঁ 2
category 1 এ তো disentitled হয়েই গেল। category 1 এ 25 বছর লিমিটেশন, আর category 2 তে বললো family members covered is applicable all pensionable retirees of class 3 and 4 irrespective of their determinant and how it is to be explained. আমার মনে হচ্ছে stands as under
stands as below
তার মানে stands as below তে category 1 আসছে, category 2 আসছে, category 1 এর সবকিছু describe করলো এইখানটা, category 2 এরটা describe করলো ওই বুলেট পয়েন্ট prior to family pension. What is your stand? What is your stand?
Request of respect, my lord.
Just a moment. Just a moment.
The benefit of grant of family pension to those family members covered under category 2 has been extended to only in respect of post 1 retired officer not to the family members of the retired officer who retired earlier.
সেটা stands as on date. আজকে এরকম আছে। এরপরের পাতায় যাও। As on date এই বুলেট পয়েন্ট 1, 2 ব্র্যাকেটের ভেতর যেটা ইনকাম ক্রাইটেরিয়া উল্লেখ হচ্ছে as it stands. What is your explanation?
My explanation is that, my lord, this is a beneficial piece of circular, my lord. And the purpose of circular is very clear from the subject matter as well as the first paragraph. My lord, go through the first paragraph. May I read my first paragraph? In terms of the such and such settlement dated such and subsequent clarification received from the India Port Association video number such and in terms of the government order convened by letter such and such, it has been decided to extend. So purpose is the extension. The benefit of grant of family pension to the dependent parent of the pensionable employee. So it is for the pensionable employee as well as to their dependent. So there is two class. One is pensionable employee, another is dependent. Unmarried, divorce, oblique widow.
Family pension to the dependent parents of the
Pensionable employees.
as
So
well
that
as
is
the daughters and manme of the pensionable employees.
I just yes, my lord.
Of the pensionable.
Yes, I am falling second category. That's I am indicating. Try to indicate, my lord. As well as to their dependent,
Yes.
unmarried, one class. Second class is divorce, and third class is widow, daughter beyond 25 years of age. Now, my lord, second paragraph. I have this second paragraph have
That you are okay. Now we are asking you on the date of death of the person.
yes, my lord. On the date of
Consideration is on the date of death of person. Pensionable employees' parents will be entitled, and pensionable employees, unmarried, divorced, widow daughters will be entitled.
yes,
So entitlement is as on the date of death of the person.
my lord.
Now the question, second rider, which you are arguing that 25 years is not a bar.
But yes,
If I am unmarried on the date of death
That's true.
and I am dependent, then I will get.
yes, my
finished.
lord. Yes, my lord.
But the
And-
thing is, how long will you get? Up to your remarriage. Whichever you way you construct the circular, the point when the employee dies is the point of considering your dependency.
Yes.
This is settled.
Degree of dependency.
Because a special bench judgment is also.
Yes, my lord. I came with that special bench judgment also.
No, you know very much. We know
No, my lord. It's my lord's judgment.
Without going into the rigmarole of the circular, let us first consider whether you pass the master with law that if you have married subsequently, divorced or married,
Widowed.
husband died, then you came back to the family.
Yes, my lord.
Now, what is the beneficial scheme? That and widowed daughter on
Yes.
the date of death, if I have at my home, if I have a widowed daughter,
Yes.
widowed unmarried daughter, dispute arose whether widowed daughter will come within unmarried daughter or not. That was the issue.
Yes.
So on the date of death, entitlement you have, there is no disputer. You are entitled from the date of death till the date of your remarriage.
Marriage, not remarriage. Marriage.
But the question is, if you are subsequently, if your husband dies, and if you come back to the father's family, in the father's family, then you will be have to be dependent upon father's family pension, na? Your entitlement on the date of death is not there. So we are not required to go into this issue, subject to what you say.
My lord, with deepest of respect, is my understanding subject to correction by Learned Senior as well, subject to correction. But my understanding is that, my lord, this circular is a specific purpose. Beneficial purpose. And this purpose is have two layered. One is that beyond 25 years or not, I think my lord is satisfied. This circular is for the beyond 25 years.
Yes,
The second part is when the right accrued and whether at that juncture I am entitled or not. These 2 points of law, as per my understanding, is that at the time of death of my mother, I was unmarried. So my claim arose on that particular date, that is 25th September. Sorry, yes, my lord. My mother 3rd November 2015. My mother died on 3rd November 2015, my lord. So at that point, my right arose, my lord. Here, my lord, kindly come to the second page, my lord, of the circular, my lord. What's the decision is? Family pension to widow divorced daughter is admissible. Second page, my lord, where bullet point is there, my lord, indicating is irrespective of the fact that, so whatever might be the fact, so there is overriding effect. So whenever that widow and divorce, I want to indicate it, my lord, because this is a special class, my lord. I try to indicate it, my lord. As per this circular, widow divorced daughter has a special class. This is a beneficial piece of circular. Widow and divorced daughter constitute a special class. Family pension to widow divorced daughter is admissible irrespective of the fact that divorce widowhood take place after attaining the age of 25 years or before. I want to emphasize on this bullet point, my lord. Why I want to emphasize, my lord? Claim of a divorced widow daughters, my lord, because of the dependency attained or not, my lord. Whenever a daughter, my lord, in our society, my lord.
If I can interrupt you for a short moment, you are absolutely right. But that is in a case, suppose on the date of the employee, you are a widowed daughter beyond 25 years.
My lord, it depends.
The date of death, suppose we are having a divorced daughter. We are having a, not a divorced, what should I say? Yes, a widowed daughter.
Yes.
On the date of death, if the widowed daughter is 25 years above also, she becomes a.
My deepest of respect, my lord. I think, my lord, in that dictum of circular is that, my lord, is not
together.
Yes, my lord. That's why I emphasis on that, my lord, irrespective of fact. I just read, my lord, once again, my lord. My lord, this class, my lord, suppose there is a 3 class. The purpose of this circular to give benefit in 3 class daughters, my lord. One is unmarried, another is divorce, and another is widow daughter. Here, my lord, widow and divorced daughter constitute a special class, my lord. Kindly read it, my lord. Here, my lord, although in the first paragraph there is a mention about 3 class: unmarried, divorce, widow. Now, my lord, in the second page, it is mentioned only widow and divorce. My lord, I just read again, my lord, for my satisfaction, my lord, kindly. Family pension to widow / divorce. Here, my lord, unmarried is not there, my lord. So, widow and divorced daughter constitute a special class. Is admissible, irrespective. The word irrespective is there. Irrespective of the fact, whatever might be the fact, that divorce widowhood take place after attaining the age of 25 years or before, my lord. Here, my lord, there is no such rider, my lord. It is a construction, my lord. On the date of death, my lord, this is a construction, my lord. And this construction, my humble submission in this regard, my lord.
I think what you are arguing is applicable had there been no widow of the deceased employee at all. Suppose in a situation where the widow has predeceased the employee, and if in your family there is a widowed daughter, 30 years old, in that case your entitlement will become. But
my lord, this is with the best of respect. That's why, my lord, I emphasis on the 4 words, irrespective of the fact, my lord. So classification of fact is, my lord, classification of
For the retirees of groups C and D post irrespective of date of years.
ক্যাটাগরি ভাগ করে ওর তো ওর আর্গুমেন্টটা হচ্ছে ফ্যামিলি পেনশন।
এবার হচ্ছে benefit of family pension to the covered under category 2 applicable to the pensionable retirees or irrespective of date of their retirement. ডিপার্টমেন্ট বাট পেয়েবল হচ্ছে এত আর ফ্যামিলি পেনশন হতে পারে কমিউনিটি স্পেশালি পেয়েবল
পার্থ ওই দুটো আলটিমেট যে ফ্যামিলি পেনশন দেওয়া হবে ডিভোর্স যেটা তুমি পয়েন্ট আউট করতে পারবে But Mr. Dotto, we want to hear from you.
Yes, yes.
You will have to, you file a short affidavit, we will hear it. Because you have to show us, Mr. Dotto, this government circular on the basis of which this change took place in your
Yes, yes.
side.
And that too, circular, if my senior friend supply it to me.
No, I will try to get it. We'll definitely
It will be helpful for me also to
2011.
settle this issue.
2011.
Yes, my lord. The earlier, so when this claimant arose, that it will be helpful for me also. But that there is any direction or there is specific.
Earlier later, 17th October 11.
In your circular is given.
Well, there is a settlement as well as a circular, both.
একটু সাপ্লাই করে দেন তাহলে আমি আর্গুমেন্ট করতে আমার সুবিধা হবে।
Well, there are three documents. I'll try to get all the three documents. At page 63, the first page. First is there is a settlement on 19th of January 2010. Second is a circular of 17th of October 2011. And third is 18th of February 2011. I'll try to get all three.
আমাকে একটা কপি
এটা তো হবেই।
অপোজিশন থেকে রিপ্লাই ঢুকিয়ে দেবো।
না আমাকে আগে দিন তাহলে আমি অপোজিশন দেখি।
তাহলে আমাকে 7 দিন তো টাইম দিতে হবে।
হ্যাঁ টাইম নিন
খুঁজে দিতে
বিফোর
Is a subject to entire grant family pension. There will be a short stay, Mr.
my lord, with the best of respect, my lord, before giving any step, my lord, may I go, if my learned friend supply this to settlement as well as I give that. I will not go through. I am giving an
Let him give an undertaking that they are not going to proceed.
I am not going to proceed. Kindly not give any stay, my lord. I just, my lord, I am giving an undertaking that I will
Let it be
not
recorded
proceed.
so that we
I am giving an undertaking, no. My lord, and my lord, give you supply this.
After you get the circular, you put in a short affidavit.
Yes, my lord.
Very well.
So we are
এক সপ্তাহের মধ্যে পারবি স্যার?
ছুটির আগে দিয়ে শর্ট মিট করে দিও, ছুটির আগে ওকে দিয়ে দাও।
I intend to, my lord, supply him the circulars, my lord, before the vacation. Kindly keep it immediately after the reopening.
সবাইকে কিন্তু দিয়ে দিচ্ছে সবাইকে দিয়ে দিচ্ছে
আচ্ছা
মনে হচ্ছে
ওটা আমরা ডিসাইড হয়েছে। Do you any affidavit is required? I don't think.
I think the affidavit is not required because
Not required.
because it's a on the points of law. Because I am not denying any fact.
Given in the trial court.
There was no affidavit before the trial, honorable single judge also.
But that's why you preferred an appeal that is on affidavit. Your appeal is on affidavit. So there is no such factual dispute. So affidavit is.
Then Mr. Dotto, you file a supplementary affidavit with those documents.
Yes.
And give a copy to
Yes.
That will.
Mr. The appellants would be at liberty to file a supplementary affidavit enclosing the.
May I take your lordship's leave?
yes, including the circular referred in the
63.
That's the notification actor circular.
The appellants are directed to file a supplementary affidavit enclosing the documents as referred to in the first paragraph of the circular dated 25th September 2022. Let such supplementary affidavit be filed within 2 weeks from date. Stop. Reply. Stop. Acha, first paragraph. The present appeal has been preferred against the order dated 7th of June 2022 passed in the writ petition being WPA 5532 of 2020. Let's a supplementary affidavit be filed within 2 weeks from date. List the matter for further consideration in the daily supplementary list of this court on 28th November. On 28th
But in
November.
that even or 3 weeks, maybe give a time. maybe.
So the 3 weeks we will close, na?
Oh, 3 weeks. No, before vacation, I will do. Before vacation, I
If
will.
my learned friend supply it, I can.
Definitely, I will supply.
Be any date, if my lord's convenient, we can any
Yes.
date, because.
18th October. Before that, I will. do.
Handicap.
18th October.
Within 3 weeks also.
By 18th October, I shall file.
Within let's say supplementary be filed within 18th October 2023. That's Mr. Shami, Mr. Ahmed, learned advocate appearing for the respondent.
Respondent writ petitioners.
Respondent writ petition submits that no contempt application shall be filed.
No, they are filed.
Filed,
They
it
are
is
They are
filed.
filed. It was in the list last occasion.
I giving an undertaking, I will not pursue it.
Mr. Submits upon instruction that the writ petitioner respondent shall not proceed with the contempt application
Great.
in the meantime.
In the meanwhile.
In the meantime. Release the matter also. Yes.
Grateful, my lord, for your question.
Circumstances. I supposed to mention morning, my lord, but I was struck off due to heavy traffic jam whole Calcutta. Now the pending appeal, my lord, they are discharging their function more than 18 years.
Which matter you are mentioning?
Matter is not in the list, but situation compelled me to disturb your lordship to include the matter because I will be ousted from the service. Continuously, we have been discharging our
Why
function.
didn't you mention earlier? Your junior did not mention.
Nobody,
Even
my lord, today over telephone, I came to know from my client.
Give a notice to your other side and tell us on Tuesday. We shall consider it and place it in the list.
My lord, my interim order is expiring tomorrow. It is in the monthly list,
Which matter?
161 monthly list.
Who is your other side?
My lord, I have informed him. He will come if your lordship kindly takes it up.
Bring the other side. At
My lord,
2 p.m.
Tuesday,
He
I
is
will-
asking me to come after 3, if possible, my lord, at 3 or 4.
Once you come with your other side, we
Fine.
will list.
well, Tuesday for medical ground, I am not used to come to
Mr.
High Court.
Mukherjee, ask your junior to mention and tell the urgency. Upon hearing the urgency, we will pass this.
Lordship.
And if you give a notice to your other side also.
Right now, there is no other side. He is not in the panel. I have to serve GP.
Fresh matter. Is it a fresh matter? When did you file it?
Not fresh matter, my lord.
Tahle?
The 2020.
20 matter you are mentioning, you give a notice, come back and tell us, we shall consider.
Lordship.
My lord, other side is present in that interim order, my lord. I mentioned just now.
কোনটা বলছে ফাইলটা বের কর।
161.
161 months.
Ah.
61.
But I am for the petition.
My lordship, I am behalf of the respondent.
What was the order impugn?
But the one repatriation order. He is the grade 2 fitter promoted to AutoCAD programmer come operator. Then again, here, my lord, he has been repatriated to the earlier post.
রিঅ্যাডজাস্টমেন্ট চেয়েছিল তো একটা ইকুইভ্যালেন্ট পোস্টে আবার সপ্তাহে রিজেক্ট করল দিয়ে এইবার নিশ্চয়ই কিছু ওয়ান পোস্ট ভ্যাকেন্ট বলেছিল বোধ হয়
Readjustment dismiss করো। When was the interim order passed?
The year 2018.
Well, order impugned in the tribunal page.
So the impugned order at the end of the petition.
Which is the order? To challenge?
At the
12th October.
12th October 2018. My lord, in this matter, I am led by Mr. Somo Mujumdar. But can it be fixed at a date? Because the petitioner is going to retire within a year. So, if the date be fixed, my lord.
Upon hearing the learned advocates appearing for the respective parties, the interim order passed earlier is extended till the end of January 2024 or until further, whichever is Place the matter for further consideration in the combined monthly list of
My lord, kindly
November
have a specific date, my lord. Otherwise, it will be difficult for us to.
What?
My lord, a particular date may be fixed. Any date, my lord. In the year November,
Is the matter
in the
for
month of
further
November or
consideration.
December, whatever.
On 12th December, on 12th December.
If
In the daily supplementary list, the matter for further consideration in the daily supplementary list of this court on 12th.
if
Pay for the respondents.
Lord, I am sitting on behalf of the petitioner, my lord.
Yes.
Yes, my lord. Any lordship look them, page number 28. It is a judgment passed by the Honorable Tribunal on 9/6/2014. Page number 28.
Why you are taking us to that?
Yes, my lord.
This is the order impugned.
No, my lord. In his judge order, the tribunal clearly explained what is the MSCP. Clearly explained.
Which order are you assailing? Which order are you challenging?
Oh, yes. My lord,
We heard you last occasion.
yes.
Your contention was that you took the point of discrimination.
Number one, my lord, MSCP is not a
You are
promotional.
not concerned with MSCP.
Yes.
Because you are challenging the order. Which order are you challenging?
Order 16 November 2018, my lord.
16th November.
2018. Page 70, my lord.
Yes. Yes. Yes, place the case. What your page 28?
Page 28, my lord. Here the previous, the Honorable Tribunal clearly explained regarding the MSCP. His financial upgradation second MSCP has been granted, that is 1/9/2008, and Great Pacific Atto. Only financial upgradation MSCP. I asking my lord anticipated promotion because examination was held on departmental promotion examination held on 2008 and result declared on 16th February 2009. But responding authorities allow me for permission, promotion from 3rd January 2012. It is my grievance. I am praying only my antedating promotion, my lord.
Yes.
Milord, can you consider page 3, paragraph 4, is the last portion.
You have, please come to the order which you have challenged, page 71.
Yes, Milord.
Whatever you are placing, that is recorded by the tribunal. Paragraph 3, admitted facts.
His financial upgradation second MSCP has been granted on 1/9/2008 before the departmental examination result declared Milord. Kindly consider it. Before that departmental promotion examination result declared 1/9/2009 and MSc granted from 1/9/2008.
Yes. Yes.
So it is my grievance that MSCP is not the same the departmental promotion, Milord. I am asking departmental promotion, which applicant appeared in the departmental examination and result declared on 2019. But the
read paragraph 4.
4, yes, ma'am. In the speaking order issued by the respondent, which is asserted to the present OA, the applicant was finally upgraded under ACP scheme, that is 1st March 2007, and posted in the scale sum with basic pay, that is PM you have 24 years of regular service, Milord. Then, thereafter, for filing of existing vacancies in the next higher post, that is carpenter grade 3, option was taken from eligible candidates and trade test was conducted on 29/8/2008, of which result was published on 16th February 2009. But the result could not be implemented for newly introduced MSCP scheme as per 6th CPC, which came into force, that is 1/9/2008.
So the trade test which was result was published in 2009, 16th of February, in which you participated. Your contention is, though I passed the trade test, you have not given me promotion.
Yes.
Their contention is that promotion was not granted, but that benefit was not extended since in the meantime the MSCP came into effect. As per MSCP, you got the financial benefit.
MSCP is a financial benefit, Milord.
Yes.
But my examination for the departmental promotion, Milord, financial upgradation and departmental promotion is not the same.
সেটা এসিপির জন্য, সেটা ডিপার্টমেন্টাল প্রমোশনের জন্য। কনফিউশনটা এখানে।
এসিপির জন্য কোথায়?
এসিপির জন্য সেটাই ওরা পরে দিয়েছে। এই যে প্যারা 5 করছে, ওরা যেটা নিয়েছে, the test application subjected to a was with regard to the financial upgradation under ACP
and not regular promotion.
এই পয়েন্টটা আসলে যে টেস্টটা নিয়েছিল এসিপির জন্য না রেগুলার
সেটাই তো ক্যারেক্টারটা এবার পেয়েছি, এটা দেখো 48টা দেখো। এসিপির জন্যই বসেছে। টেস্ট অন এসিপি সেইটা ট্যালি করে যাচ্ছে উইথ প্যারাগ্রাফ, এই জন্য
the trade test was taken to grant ACP, not to give promotion.
But Milord, can you consider one point? Before the trade test, I already applicant enjoying ACP's grade. Yes, my lord.
You come to page 48.
Yes, my lord.
You are hereby informed that your test on ACP will be held on 29th August 2008.
That is, my lord, contradictory. Because, my lord, before that, my applicant already enjoying the ACP grade. The first
You are Mr.
application.
Goswami, you are not considering what we are saying. What was your claim before the tribunal? That give me promotion to the post of carpenter grade 3 since I have passed the trade test. Now page 48 shows that the trade test which was held was for grant of ACP benefit and you participated in the same knowing fully well.
Yes, that is correct.
So Mr. Goswami, now how can you, now you are saying that you give effect to the result of the trade test which I passed in 2009 and appoint me to the post of carpenter grade 3 antedating my promotion. That is with effect from 2009.
My lord, and one point is, as per this letter, my lord, applicant applied for ACP scheme. But in the meantime, my lord, they declare MSCP, my lord, for upgradation of the financial benefit, my lord. And my result declared after that. Before that, they declared this, my lord. My result declared on.
Result was declared on 16th of February 2009.
Yes, my lord.
That is why you wanted promotion from 16th of February 2009. Now that promotion, what is ACP? It's assured benefit scheme.
After
Why? Because you have worked 10 years without getting promotion, so government is giving this.
Yes, my lord.
So tribunal has said that you have not suffered any financial benefit. Moreover, subsequently, you have been promoted to the post of carpenter.
My lord, that is very important point, my lord. If I promoted to the higher post, then all the financial benefit will be gained, my lord.
That is been given to you from 2011. Kindly read paragraph 5 and 6. Now you have already retired, na?
Yes, my lord.
Sorry, Mr. Goswami. The present writ petition has been preferred, challenging an order dated 16th of November 2018, passed by the learned tribunal in the original application, being OA number 350/1923/2050. Mr. Goswami, learned advocate, appearing for the petitioner, submits that in spite of emerging to be successful in the trade test, of which result was published on 16th of February 2009, the petitioner was not given promotion to the post of carpenter grade 3. Such argument as advanced was glossed over by the learned tribunal and no finding was returned on the said issue. Stop. Mr. Goswami further argues that the grant of benefit of ACP and MACP has no connection with the promotion to the with the promotion to which the petitioner became entitled. Having emerged to be entitled on the result of the trade test. Stop. The learned tribunal failed to appreciate such issues and failed to appreciate such issues, and as such the ordered impugn needs to be interfered. Per contra, Ms. Alam, learned advocate appearing for the respondent, submits that the result of the trade test could not be implemented for newly introduced MACP scheme. But why you have not granted the ACP benefit then?
Lordship, that ACP benefits were not granted, Lordship, because of the six pay commission scales were given. So that was given, and thereafter the MACP. So
MACP he got ultimately.
Ultimately he got, but then with the implementation of the sixth pay commission, that grade they got. Therefore,
And
he
the
was
trade test was not for promotion to the post of carpenter.
and then when he was promoted as carpenter grade 3, he passed a trade test. He appeared and passed a trade test in 2012. It's not that he did it without a trade test. Lordship will kindly see.
2011.
Yes.
That was a next trade test.
That
which
was a trade because he was not promoted to carpenter grade. He was a Khalasi helper, but he got that scale with the sixth pay commission benefits. So he did not.
That means of the promoted post.
Promoted. Yes, he got the scale of promoted post, but he was promoted as grade 3 because that test was not the ACP test. Actually, there was a change. I mean, ACP and the MACP, there were changes in regulation. ACP required a trade
So
test.
it was not a trade test for promotion to the post of carpenter grade 3 of 2009.
For as per the ACP rules, it was. But then when the MACP was introduced.
How can ACP rule it was? Because trade test is for promotion. ACP
Lordship,
is for grant of financial benefit.
Lordship will add to the scale of carpenter grade 3, Lordship. Attendance for upgradation on ACP, Lordship. That is what it says, not a promotion. Trade test for upgradation of pay. The ACP rules require. Page 48, Lordship.
Page 40.
Yes, 48. That was a trade test for upgradation of pay from helper on ACP scheme to be held. So it was an upgradation trade test. The ACP scheme had that provision. MACP was an in situ promotion, the rise in pay scales.
Then why he is saying that he...
That is... But Lordship sees it's very clear.
Ashok, clear? Miss Alam learned advocate appeared. Next paragraph. Drawing our attention to the document annexed at page 48 of the writ petition, Miss Alam learned advocate appearing for the respondent submits that the trade test held in the year 2008 was for upgradation of pay. Of helper chat Roman 1 on ACP scheme. Stop. The trade test thus, such on ACP scheme and not for regular promotion as claimed by the petitioner. Stop. The petitioner had also not suffered. The petitioner had not suffered any financial, had not
My Lordship,
had not suffered any financial loss and had not suffered any financial loss. Stop. And no junior was promoted to him, superseding his claim. She further submits that subsequently the petitioner was posted as carpenter grade 3 through test with effect from 3rd of January 2011.
2012.
In the said conspectus, the learned tribunal refused to exercise discretion in favor of the petitioner, and there is no infirmity in the order review. Heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. It appears that the trade test held in the year 2008 was for upgradation of pay on ACP scheme. Stop.
For the benefit of upgradation on ACP scheme.
It appears that
held in the year 2008 was for upgradation of pay
on ACP scheme, as would be explicit from the documents annexed at pages 48 and 50 of the writ petition. 48 and 50 of the writ petition. Miss Alamed last paragraph. And
Lordship, Lordship, kindly.
In the same conspectus,
3rd January 2011. So it's next. It appears fully.
it appears it
It appears
that the trade test held in the year 2008 was for upgradation of pay on ACP scheme, as would be explicit
from the documents annexed at pages 48 and 50 of the writ petition. It further appears that the petitioner did not suffer any financial loss and no person junior to him was superseded. Stop. The petitioner subsequently appeared the petitioner also availed promotion to the post of carpenter grade 3 subsequently. Stop. Upon considering the factual issues, the learned tribunal arrived at specific findings, and we do not find any infirmity in the same. In view thereof, the writ petition being such and such dismissed, shall, however, be moderate.
After the passage, kindly consider, my lord, rejoinder of the applicant, my lord, kindly, page 52, my lord, kindly consider one point.
That is for the juniors you said. That was no awardment in your original application. Yes. Next. Yes, 13.
Lord, this appeal, my lord, was supposed to be listed on 3rd of October as directed by your lordships, along with another appeal, which was to be filed by us, and we have also filed that appeal.
John, that we have kept it on third.
My lord, Mr. Kishore Datta had appeared on the last occasion, my lord, when leave was obtained from your lordships. And before that, my lord,
Yes, next. Hardy ওইটা শুদ্ধ তাহলে। Yes, next.
Next, item 14.
Yes, Mr. Vati.
I appear on behalf of the
I
state
appear
for the appellant. It's a very short issue.
What is the application?
Application for stay, though my writ petition has been dismissed, kindly takes up the order before your lordship and order impugned at page 58 of the stay application.
Yes.
The petitioner is the wife of the private respondent. Now, there was a dispute. The allegation is that 498A and other provisions, even 307 and 313 of the IPC, forceful abortion. Now, yes. Now, I am a teacher of a school. I stood 10th in the SSC. I am doing service at Itahar. What has happened is, I approached this court questioning that the second appointment of my husband has been done when a charge has been framed by the court below, Raiganj court, and the date of trial has been fixed. There was no police verification, and without the police verification, he got the second appointment in a government service without the police verification. This is my case. The learned single judge, kindly have a look to the order, has rightly mentioned that I have to go to the tribunal. But the only difficulty is, the court said, page 59, furthermore, got it? Page 59.
Yes.
Furthermore, this court finds that the private respondent was so government employee, writ petition is not maintainable. Then it is by this point, it's correct. Now, your lordship, have a look to the earlier paragraph from the submission.
Yes.
Of the parties made, it appears that the dispute is primarily a private in nature. This is the point. This is the line I want to strike out from the order. Because if this is a private dispute, private in nature, I cannot approach the tribunal and ask for relief.
Who told you? From the submissions and from the dispute which has been agitated in the writ petition.
Yes.
When you will file the tribunal application, you will make appropriate pleadings.
No, only this point, that is troubling me.
We will say that this observation is on the basis of the amendments made in the writ petition.
I'm grateful. Only this much.
This will not stop him. When you will file the tribunal application, you will make another sort of, you have to place your case, na? Because
I was not there before the first court. I was not there before the first court. This is a change brief.
No, Mr.
I filed the appeal.
Your contention is that if this point is, if this portion is to remain, then you will not be able to apply for adjudication appropriate.
Absolutely, before the tribunal. Only this much, kindly clarify this. Otherwise, I have no other grievance. I have to go to the tribunal. Because it's a government service.
Why you unnecessarily coming with invite and order from us?
But because of this line, this is a private in nature.
This will not at all be a bar.
But kindly mention this. But otherwise, the tribunal may say, the High Court has said,
say that the observations made are in the light of the pleadings in the writ petition. We cannot say that what case you will make up before the tribunal.
No. In the writ petition, I have annexed the writ petition. But in the writ petition, I have specifically mentioned that the private respondent has got the job without the police verification. When the case has been tried and I approached the High Court for spirit disposal, the High Court has passed the order for spirit disposal. The charge has been framed under section 307, 313 and 498A. When the charge is pending, the date of trial is fixed in November. I have approached the wrong forum. It is true. But only this line is troubling me. Otherwise, I would not have preferred this appeal. Only to strike it out. Right?
Leave it to lordship. My lord, what thing?
When the court held that this, kindly see his next line.
Yes.
This court is of the opinion that the writ petition is not maintainable since the dispute is a private in nature. So the court held the writ petition is not maintainable. It's a private dispute.
ঠিকই বলেছেন। ঠিকই বলেছেন।
Kindly turns to page 57.
State is a party of state versus
criminal cases জন্য আসেন। ওর অ্যাপয়েন্টমেন্টটা কোঅপারেটিভ হাজবেন্ডের অ্যাপয়েন্টমেন্ট আমি স্ত্রী গন্ডগোল private respondent
Private respondent is the husband. My lord, kindly see page 57. The framing of charge and fixation of date of evidence. Page 57.
very good. How does that affect you?
No, it affects me because
What was your prayer in the writ petition?
kindly see my prayer, my lord.
Yes, show us.
Yes. The writ petition is annexed. My prayer is at 31. Start. Page 32. Page 32. 31 start. It starts from page 31, comes to page 32. The secretary of the Swanso district magistrate Hooghly, now he is posted in Hooghly in land reforms department, to initiate an inquiry against the private respondent for the alleged suppression exercised by him in his police verification report. Now, my learned friend can apprise your lordship whether any police verification has been done or not.
Why you are making this this is an allegation you are making against your husband.
True.
So is it not a private allegation?
It's a private allegation. But kindly have a look to
state to do it.
I tell your lordship, when a criminal case is pending, when a charge has been framed, he was in custody for 28 days. Now, he left that job and joined a new job.
That was maintenance proceedings.
No.
Then
498 proceeding.
498.
Yes, 498 proceeding, 307 attempt to murder and 313 forceful abortion. The charges has been framed. Date of commission of offense. But the trial date has been fixed. November. Now, suppressing all these things,
yes.
He applied for the second post and he is the RI.
Cancellation of his appointment. You
No.
want that his appointment should go.
But this is not the appropriate forum. The court has held that I have to go to the tribunal. But the court mentioned that this is a private dispute. But if I go to the tribunal, this point they will take. Kindly, only clarify this line, nothing else. But I have no grievance against anybody in the High Court. I have no remedy. Only this much. I will go to the tribunal. একটাই এসছে আমি তোমাকে ফেরত দিয়ে
You are for the husband.
I'm for the state response.
State.
State.
Where is the husband?
But the affidavit of services before your lordship, everybody has been served.
Husband contested the
Yes. Court in the court below, before the first court, the husband contested.
When did you serve Mr. Bhattacharjee?
একটু দিন আমাকে কপিটা
Oyon Boral for the respondent
My
number.
lord, I have served on
Respondent
13th of September.
Private respondent appear.
Track record ta nahi?
13th of September.
Yes.
Do you have the track
My
record?
lord, just now within 2 minutes, my lord, I'll get the track record. 13th of definitely it has been, my lord, served.
Should have ensured the track
My lord,
record.
I will do within
mentioned-
within 2 minutes. My lord, I am not against the husband here. My lord, I am against a line of the order.
All right, but we will, he's entitled to a
Absolutely.
service.
Absolutely. But kindly make a very short passover, my lord, for 5 minutes, my lord, I will do it.
Oyon Boral is the advocate.
I don't.
You have to complete service and come.
My lord, kindly give me 5 minutes time, my lord, so that I can bring the track. My lord, my junior has gone to the, my lord. 5 minutes passover, my lord, I will do it. সত্যি my dear.
Come on Tuesday with the affidavit of service. Please come on Tuesday.
Yes.
Complete the evidence, and if your junior comes to know about Boral, give a notice that it will appear on news. Because he appeared.
Yes,
He
yes,
wants to
I've
pass
seen that
the order
he has
in
appeared.
বইটা দেখে নাও, বইটা দেখে নিও।
হ্যাঁ দেখে নিচ্ছি।
Yes, next. Next.
স্টেট তার একটা কথা হচ্ছে দেশের যা ইয়ে আছে রুল আছে, যেমন যদি কারো এগেনস্ট এরকম সে জেল আছে তাহলে সে যে সাসপেন্ডেড হবে, এটা হচ্ছে রুল। একজন সিটিজেনের এটা দেখার অধিকার আছে যে রুলটা ইজ প্রপারলি, আদারওয়াইজ হি উইল ফিল চিটেড। তাহলে সেদিক থেকে এখানে একটা পাবলিক ইন্টারেস্ট আছে। যদি আমি দিতে চাই এটা বলতে চাই,
আমরা এক্সপ্লেন
হ্যাঁ যদি ইট ইজ কামিং ফ্রম এ প্রাইভেট কোম্পানি, কিন্তু
হ্যাঁ কিন্তু
দেয়ার ইজ সাম পাবলিক
কেসটা তো ওরকম ভাবে মেক আউট করতে হবে যেরকম সেই প্লিডিংস এ যদি ও প্লেয়ারটা সাপোর্ট না করে ও বলতেই পারে সেই জন্য আমরা ক্ল্যারিফাই করতে observation as regards the nature of dispute was pertaining to the pleadings in the case. Pleadings ছাড়া তো relief claim
But in 37, I am for the respondent.
37 has not been called as yet.
Oh, board is showing 37.
My lord, 37 in this matter, I led by Mr. Sudip Krishna Dotto. I just praying, my lord, today's accommodation, my lord, in this matter, we'll praying for my lord's kind leave to file a supplementary affidavit because we want to annex a one important document.
ফাইলটা তোলো এবার থেকে ফাইল সব
The proposal has not filed until evening.
Yes, who is for the petition? For the petitioner.
Yes, my lord. I led by Mr. Sudip Krishna Dotto, my lord. Praying for today's accommodation, my lord. Only, my lord, I want to show one document by way of supplementary affidavit, my lord. Kindly fix it next week, my lord.
There is a direction for affidavit.
Yes, that is, my lord, also.
To use supplementary evidence, they have to deal with the apartment.
Yes, my lord. My lord.
Have you filed any opposition, Mr.?
Yes.
You have already filed.
Yes. Matter is complete.
Then at this stage, what supplementary?
Because, my lord, one document that has been missed, that was.
Give the document to Mr. Vajpayee. How can we, if again supplementary, what is the case about?
Compassionate appointment.
Well, no further supplementary affidavit can be given. Opposition reply you have given.
Yes. Reply ready, my lord. Reply.
No.
My lord, we have served a copy, my lord, today.
Not today, what can be done? You will be suffering. It will again go on rotation. Next matter. Mr. Bajpayee, you are there in this matter also. Gurujit Samant. এগুলোকে next you are there, Mr. Bajpayee. Item 38. Yes, next, Daku.
My lord, this matter I missed it, my lord. I am to check on your lordship. Kindly.
দেখে যাও। 40?
I am for one of the respondent, PF authority, lordship. There are other respondents also.
Yes, what is the?
My lord, this, my lord, matter pertains to, my lord, the compassionate appointment, my lord.
Under whom?
My lord, under the EPFO, Employees Provident Fund Office, my lord,
Not
organization.
appearing.
Yes.
Was any direction for evidence?
Lordship, we like to file affidavit. I know. There was exchange of affidavit. Oh, what next?
No.
There was no direction, my lord, per se.
No,
Lordship,
tribunal evidence were exchanged.
yes, my lord, there was exchange of
Lordship,
affidavit.
here we like to file
Everything
an
is there on
affidavit,
the
lordship.
record. Nothing more to
Your
substantiate, my lord.
opposition is here. What is the problem?
Before your lordship, we have not preferred any opposition, lordship. That was before the London tribunal bill.
Yes, we are not required. Na? It is the same thing they are agitating.
As your lordship, because they have taken some ground, lordship, which you need to deal with, lordship. If your lordship allow me, then we can file our affidavit, lordship.
We did not take any new ground, my lord, here. My lord, here, my lord, the point is very simple, my lord. My lord, the petitioner, my lord, applied for the compassionate appointment on the death of the my lord, father, who was a clerk, my lord, in the my lord, in the EPFO, that is Employees Provident Fund Organization. So, my lord, he passed away, my lord, in 2014. So, my lord, during the thereafter, my lord, his case was being considered. My lord, the son was, my lord, called upon before the screening committee, and my lord, the screening committee, upon my lord producing the financial condition and other situations, my lord, was pleased to direct that yes, you are eligible for getting compassionate appointment. And in this meantime, my lord, what happens in 2015? There were, my lord, a new rule that was introduced in the respondent's office. So that new rule, my lord, said about, my lord, a 100-point roster marking system. So pursuant to that new rule, my lord, they thereafter rejected my case. My lord, challenging that, my lord, I went before the learned tribunal, and the learned tribunal was pleased to, my lord, observe that following Canara Bank and Balbir, the petitioner's case has to be considered. So, my lord, lordship has to be considered. Balbir and Canara Bank.
Then
So, my
what
lord,
happened?
the lordship knows, my lord, Canara Bank and Balbir, both of them say that my lord, compassionate appointment has to be considered from the date of the scheme, which is prevalent at the time of the death.
Then what happened?
My lord, they rejected once again, saying the same thing, that subsequently in 2015 there was a new 100-point roster came. We once again, my lord, came before the honorable the learned tribunal. The tribunal thereafter, my lord, said that one of the 3 judges bench, my lord, has been considered over there, and my lord thereafter rejected the case by saying that yes, 100-point roster has been introduced afterwards, and by this 100-point roster you are not eligible. So this is why I reject your case. My lord, my points before your lordship today, that on one hand, when in the first round of litigation before the learned tribunal was pleased to, my lord, direct that my case to be considered on the basis of Canara Bank and Balbir, which, my lord, says that the scheme at the time of death will be prevalent. And thereafter, my lord, when on my second round of litigation, when I approached the tribunal, my lord, the tribunal quotes the judgment which are, my lord, against us, and thereafter, my lord, rejects my case.
You
So-
relied upon any judgment of coordinate bench?
My lord, yes, I did, my lord. My lord, that is the most recent judgment of this honorable court. And that, may I, my lord, take your lordship to that, which, my lord, specifically states that the scheme which is prevalent, my lord, at the time of death will be applicable for the purpose of consideration of a compassionate appointment. My lord, that judgment, my lord, is passed on 25th of February. And I also, my lord, relied upon, my lord, the latest Supreme Court judgment, my lord, in Vimesh Bhimappa, if I can hand up to your lordship. That I've also relied upon before the learned tribe.
Now after vacation, Mr. Rai.
My lord, lordship will kindly appreciate, my lord, this is, my lord, a person, my lord, who has been suffering, my lord, and in extreme distress, financial distress. Only is in extreme financial distress, my lord. Only one thing, my lord, why it was adjourned on the earlier time, my lord. There was a point, perhaps my learned senior friend, my lord, will be taking up that point again. My lord, they referred to a particular letter, which I myself wrote, by saying that let my case be considered in any other scheme and let at least my case to be considered. So by taking recourse of that particular letter, which I gave, my lord, they are saying, since you said, this is why your application will be considered as per the new scheme and everything.
Where is that? Which letter? There is no recording.
My lord, it is submitted before the this honorable court, my lord, on the earlier occasion.
Which letter you are speaking about? Yes,
Sir,
which letter you are speaking about?
I
Lordship, page
subject to
70.
correction, page
Annexure
70.
A4, page 70.
70.
No, actually, initially the petitioner made application. That application was considered for appointment, and thereafter the zonal head office, after considering the application of the petitioner, the same was rejected considering the 100-point methodology. Subsequently, the applicant came before us accepting the guidelines, lordship. That is page 70. That is the letter. Lordship, you will find from paragraph 3, lordship. In view of the above circular guidelines, I submit the following information. He has on his own accepted the guidelines, lordship.
But the court relegated, na? The earlier occasion court said that you have to consider as per the rules on
No,
the
my lord,
date
the court, lastly, the tribunal rejected their application considering that it would be considered from the date of the consideration, not from the date of death.
But, answering, but I addressed before the
I am referring the order date 22nd of March 2023.
Is
Or
this the judgment you are relying upon? What did it mean judgment?
the relevant part, if I can take your lordship to.
We keep it in the supplementary list and decide. Have you given a copy to him?
Yes,
Yes, ma'am.
কোন copy?
Absolute.
No, judgment
Petitioner সাহেবের আগের দিন যেটা জজ সাহেবই দেখতে বললেন আপনি। But the point for which, my lord, my learned senior friend was directed by this honorable court, my lord, to take further instruction that whether the incumbent can, by way of writing a letter, whether by writing a letter can, my lord, forego the legal right that he has got.
That is what we are questioning.
Yes.
That judgment was considered by his lordship,
And
my lord.
thereafter, my lord, and also
Earlier
It
lordship.
was hard for his
Yes, yes,
real time.
yes, yes. This was hard, and
my lord, it was.
the interim order was.
Standards order.
Yes,
It
my
was,
lord.
yes.
This
So you
was
should have
considered.
pointed out to that court.
Well, I already pointed out, my lord, handed up to your lord, this on that honorable court, this on this particular order.
This was not
Adjournment,
considered.
adjournment was sought for, my lord.
No.
So this is why, my lord, this matter was adjourned.
Initially, the prayer was rejected, lordship. তোমার ওটা তো অনেকটা আছে, আমার তো এটাই তো সেম তো।
হ্যাঁ, আমি আরেকটা কপি আপনাকে দিয়ে দিচ্ছি।
মেহরুন্নিসা কোনটা রেফার করছে?
নামটা বলতে
রেফার এই পেছনে লিখে দিন তো। ওটা না। This matter was heard at length, Lordship. And you'll, yes, by the coordinate bench, my lord, and the interim order was refused.
interim order, I did not even pray.
No, that
There
is
was no interim order as well. What?
prayer. Actually, he was given another opportunity to make his case, Lordship.
What can be done? Now it is a separate basis.
Yes, my lord. No, my lord, I'm not on this, my lord.
What can be done, sir?
Yes, Lordship.
And my lord, another point, my lord, I just took to your lordship that my case,
Documentary list on 28th November. Give a copy of the judgment.
but
upon
28th
which-
November, my lord, will be my lord. If I just request, my lord, if it could be my lord accommodated before this side of vacation. As your lordship.
My brother won't be here from
Your
night.
lordship. As your lordship.
আমাকে একটা জাজমেন্টের কপি দেবে না?
Please give a copy of the judgment upon which you will be relying to your friend.
And
And,
I'll once
his-
again do that.
Huh?
My lord, I will once again do
Person.
that. Because
You are-
that judgment was handed up to my land senior friend. This is why matter was
No,
acted.
no, I have not received. Sorry, I have not received.
কোথায় গেল? 28th November দিয়ে দিয়ে supplementary list. Yes,
একটু মনে করে দিয়ে দেবে না? Lordship.
Time.
Ballot 40, 41 and 70. One analogous matter. My lord, this fact, my lord, I will state the fact of the case.
who's your other side, Mr.
My lord,
Chakraborty?
I am for the respondents.
Respondent,
Yes,
Union of India appeal.
yes, they preferred appeal. My lord, what happens, my lord, I am out of,
But it is their petition, Mr. Chakraborty. Did it appear earlier?
my lord,
Eh?
it appeared. No, it could আসেনি না, not in this court, for this court.
Pradeep Kumar Kundu.
Lord, I will again,
Your supplementary, Mr. Agarwal.
Lord, for the last 10 months, my lord, we are out of service. Although, my lord, we got order from the tribunal. My lord, our application was allowed. No alternative suitable post was given. My lord, I have brought the circular also. As per the circular, we are entitled because we are drawing, my lord, 2000 grade pay. Now they have placed, my lord, in the grade pay of rupees 1800. We are working as a constable. We are medically decategorized. Now, suitable alternative post was not offered. And they have violated 1303 of IREM. And my lord, I have brought the judgment also passed by this coordinate bench. এই circular গুলো দিয়ে দিন। তখন কোনো
Yes.
Now, what was the prayer you made on, why did you make a prayer for death related job? Under these circulars, it has to, they are under an obligation to place you in the
Suitable also.
in a suitable place having the same scale of pay. But why did you represent Mr. Chakraborty that give me a death related job? In that case, in the recent order, we have not seen, maybe that death related job will not inure to your benefit.
It's related job, my lord, others got clerical job. Because my lord, kindly see.
Are you there in this matter?
I am 46 petition. I am for the petition.
You are for the petition.
My lord,
In this case, not 46 item
What
number.
number
46. I
item?
am sitting here on. Nothing. Any
Topon
disturb-
Maji, my lord, this matter. Topon,
This is Topon Maj.
my lord, here what happens, my lord? The applicant was working as a constable, grade pay is rupees 2000.
Yes, we
Now,
have.
my lord, MSCP, my lord, 2400. Now, my lord, I was placed as a my lord,
And now in paste in a scale of 1,800.
800. That cannot be done. This is the circular.
Very good. Now,
And my
if
lord,
there is no vacancy,
then my lord, I
we
may be kept in a supervisory post. That is the circular.
till a supervisory post is, my lord, till alternative post is available, I may be placed in a supervisory post. That is the circular, and this is the judgment of the Honorable Tribunal, judgment of the Honorable Apex Court in Kunal.
It has not set aside the order of 30th September 2020. Tribunal has said such alternative employment shall hence be searched out and offered to the applicants within 2 months.
Yes.
The order dated 30th September 2022, which you challenged, that was not set aside. Where is that order? 30th of September 2022.
They have not annexed the original application.
Do you have the copy, Mr. Chakraborty? By the 30th of September 22, they demoted you and posted you in 1800 grades. That you are agreed by.
Yes.
Petitioner. এটা ফাইল করে বসে রয়েছে কন্টেম্প্ট করতে। Contempt you have filed.
My lord,
Contempt you have filed.
my lord, I have filed contempt, my lord, execution of the court's order under Rule 24 of the CAT procedure rule.
That has been adjourned.
That is, my lord, not taken. But they are taking adjournments, my lord. Court is not. Nowadays, my lord, we do not know when the matter will be taken up before the tribunal, either contempt petition or execution petition. But for the last 10 months, my lord, we are out of service.
Lower skill. 1800 স্কেলে নামিয়ে দিয়েছে।
ও আচ্ছা আচ্ছা আচ্ছা।
সার্ভিসে
My
আছে।
lord, my lord, this similar point was decided by the court. Similar issue was decided, my lord. My lord, my lord, may I read the circular? My lord, may I read the circular, railway board circular?
Circular. So was the order impugned 30th of September 20.
That is annexed in the original application.
প্রদীপ কুমার কুন্ডু।
22/11/2022 Records reveal that the present application has been filed affirmed before this court on 19th April, has been filed before this court on 26th April 2023. About 5 months after the order passed by the tribunal, learned tribunal. No one appears today on behalf of the petitioners, and no accommodation has been sought for. Though Mr. Chakraborty, learned advocate appearing for the respondent, is present. So to give a further opportunity to the petitioner to appear, the matter stands adjourned. Please the matter for No accommodate though, no accommodate though Mr. Chakraborty or the advocate appearing for the is the matter for further consideration. To give a further opportunity matters. To give a further opportunity. It is the matter for further
My lord,
consideration.
fourth, my lord, other matters are there. On fourth in the, it may appear in the supplementary list. Fourth matter.
Daily supplementary list of this code on 4th November. 4th November. 4th key. 4th November.
4th October.
4th October. Yes, next. Bring
My-
bring
my-
your writ petition.
My lord,
Your what has been the order in your implementation execution order? You have to show us, na? Otherwise, why should we should unnecessarily place in this supplement?
my lord,
You are already in service, you are earning money. You should be equipped with all the documents, Mr. Chakraborty.
কোনটায় মানে
হ্যাঁ?
জামাই নিতে তো সেটাই দিচ্ছে না রিডিউসড স্যালারি দিচ্ছে
Reduce the
ইউ আর নট ড্রয়িং রিডিউস স্যালারি
no, I have not joined, my lord. I am without service.
Oh,
Because-
you have
you have not
that
joined
post
to the
also.
lower
I have not. If I join, my lord, then my lord, my right will go. If I join, my lord, I cannot join in the lower post. Because this is the circular, my lord, issued by the railway board, as well as, my lord, the judgment passed by the Honorable Apex Court and Disabilities Act also, my lord, there.
Yes, next.
And my lord, physical condition is such, my lord, I cannot join in that post. Housekeeping, my lord. I have, my lord, demoted to the post of housekeeping. Yes, my lord, this is the housekeeping post.
They will be giving you in an equivalent post.
No, it is not equivalent post.
They
no
will,
they will as per circular
They should accommodate me in a
should
suitable.
accommodate
This is
you
the,
in a
my lord,
suitable-
circular, and my lord, 95, that act, my lord, came into effect. That is Disabilities Act. And following Disabilities Act, Railway issued a circular. Railway Board issued a circular.
next.
40, 41 and 71, my lord. Same issue.
41. Same order.
Same order.
71.
71
No, no, sir. Call hole তারপর 41. Next. 40 ওই দুটোতে দিয়ে দিন। Not today করে দাও 40 দেখে যাও লিস্টটা কে কে পিটিশনার না অ্যাপিয়ার করলে আমরা লিস্টটা তো কল করে দিই। Yes.
44, I am on behalf of the my lord petitioner, I am praying for not today, my lord.
Not today, চাইছে আচ্ছা আর কিছু আর কিছু করার
ট্রাইব্যুনালটাতে Yes, next.
My lord, I'm good.
দেখে যাও।
This is, I am for the petitioner, my lord.
Petitioner,
Yes, I am in of India.
Union of India. Who is your other side?
That I know I have the application. Sub the
The
copy,
application.
yes.
Any scope for interim order?
No question of the interim order.
Yes.
Interesting case, my lord. Kindly see, very interesting case. Yeah, government money has been lost. And how to government money is lost, that is kindly see. Against the order of the learned tribunal, that is he is a postmaster. First, I am challenging the first point. It is a divisional matter, division for tribunal matter, but it has heard the in the single bench. According to rules of the administrative rules, kindly see.
Come, Mr. Mukherjee.
Yes.
Give a notice to them. Come on the next.
Fixed
no
and
scope
fixed
for
and otherwise
interim
very late. It is hard by the justice tribunal here. Yeah, it was hard. And lordship kindly fix up the day. Otherwise fix that way. long is pending.
Will call on from
And
9th
ma-
October again.
12 to 21 lakhs and 61,000 is lost in the government money.
So
That is
matter will be
yes, very urgent matter, my lord. That is the recovery from the Sarkar. And who is the postmaster?
Where is
Is
your
what has
original address?
happened, my lord? Kindly see what happened. Savings bank, kindly
See the order which was last passed. Show the original application. You took time. Read the order which was passed. না দেখে শুনে
আমি তো দেখিনি order.
see this is the conduct.
I do not know that file to be.
It was passed in your presence and you do not know. You do not know.
All right, fix the date of the lordship. Early, I'm early the date. Lordship. I'm praying. That I'm praying. That is a division bench matter, my lord. Kindly see. Shamal Kumar Mukherjee, S.K. Mukherjee.
You took adjournment with an undertaking that you should produce the copy of the reply.
Copy of
which was filed before the time. Where is that reply?
ও ভুলে গেছে ভুলে গেছে দাঁড়িয়ে
Reply.
ভুলে গেছে।
That is the junior is that.
Mr. Mukherjee, in your presence order was passed and you are now shouting. Huh?
And in fact,
এবার ধরলে যখন
I'm
বললে
submitting the
Borde
facts of
যখন
the
বললো
case. What
junior.
is the gravity of the case? That I am-
Gravity of the case we understand. এই অর্ডারটা দেখাও তো।
Right.
Court thought that reply is
That I have not
required to
seen
be-
the order. All right, I have
required
not
to
seen
be
the order. Yes,
or
also
considered.
order, but that I have not seen the order.
আছে নিশ্চয়ই।
That you have submitted before the learned tribunal, that has not been considered.
You
That has
have
not
that.
been considered. That is subject, I have not filed any reply.
We are adjourning for
He has
your
filed-
benefit.
He has not filed any reply in this concern, in this matter, but argue the case in this matter before the tribunal, tribunal has not
Alright.
been considered.
Bring that document which you said you will bring on
Yes.
the next date. We will hear.
And please come, next day fixed and for fourth or fifth or
We are not fixing. It will be called on Mr. Mukherjee.
fix it will be very urgent to 21 lakhs and 16
All right,
involved in
come.
this matter. There is a government
It
fund.
will be taken up. Why don't you understand?
All right, I'm giving you.
Yes, next matter.
Please take it, fix the date, lordships. Before vacation, fix the date. Fix any date, lordships.
Yes, next.
47, my lord, I am for the petitioner.
Yes.
Lord, your lordship, see, the
The
last
other side
occasion.
is afraid of you. He has not come. দেখি কি
Justice Velumuni, my lord, passed an order, my lord, to the effect, directed the BSNL to submit a report. Your lordship, kindly see the last order passed on, my lord, on 26th June 2023. That thereafter the matter has been transferred. Here, my lord, the weightage mark is not given for accommodation. Pre-service.
So what was the case about?
Case
Weightage
is
of
for
10 marks for what?
died in harness. There is a mark is given, my lord, 55 marks is required to get this employment on compassion ground. Here, my lord, they have not given mark accommodation on weightage mark for accommodation. But my lord, two report was submitted, two different report was submitted.
So, weightage of marks means
Weightage of mark regarding the accommodations.
accommodation of
Accommodation,
the deceased.
if you know, accommodation is regarding the rented house or the other houses, my lord.
That means your predecessor who
Yes, yes,
expired.
it is a predecessor, yes, my lord.
If there is a even rented house is given one sort of mark. will be
Even my lord, the person, my lord, who filed the writ petition, my lord, they have inquired whether he has staying in a rented house or my lord own house. My lord, here two report was submitted. One report, my lord, they have said that I have a tile shed house, and another report, my lord, they submitted on the basis of the neighbors. Your lordship can see the two report. As a result, my lord, your lordship can see first report was, my lord, your lordship can see
that
first.
has been quoted in the order.
Yes.
We have seen that.
Yes, page 101. So the is the contrary report, page 101.
No. Change the order.
Tile roof. And another report is page 104.
No, Mr. Bodua, kindly explain to us what was the case.
The case is this, my lord, it's a died in harness case, my lord.
Hmm.
What has happened, my lord? The petitioner's father died. Thereafter, I came before this court, and court passes an order to consider the case. They have not considered. Thereafter, my lord, the BSNL preferred an appeal. The appeal was dismissed. Then, my lord, again I filed the contempt applications. But during contempt applications, so the authorities this trial court has considered the case, considered the case. But in the meantime, my lord, BSNL came into the under tribunal, CAT. For that reason, yes, I went to the file a CAT, my lord, central tribunal.
This weightage, where is the scheme?
Yes, yes, the scheme, my lord, I am showing the scheme. The scheme is, my lord, your lordship, turn page. Page, my lord, page, my lord, 88.
88.
Yes.
It.
And order is, my lord, the page 87.
When did your father die?
2001. Thereafter, the litigation is continuing. Page 87 is the order, your lordship, can you see?
No. What is the scheme? Weightage, where do we find?
That is, my lord, first, my lord, your lordship, can you turn page 87. Page 87, your lordship, can you got it?
Show us 88. This
Page 87, first, your lordship, can you talk page 87. Here, my lord, clearly examine your case in respect of last paragraph. Dependent weightage basis, family pension, left out, service applicants, weightage, terminal benefit, and accommodations, and observe that as the net weightage point obtained by you is below 55, and less, your case is not recommended for compassionate ground appointment. Then, my lord, your next page, your lordship, can see, I got 50. And accommodation is a my lord 15. Accommodation nil. They have no accommodation marks was given to me.
How much is there for accommodation?
15.
1-5.
1-5.
Now this,
I would have get appointment, my lord, if I.
where do we find applicants weightage accommodation ward where you are finding?
My lord, accommodation 0, nil, right hand side, my lord.
Where do you find the ward accommodation?
Accommodation is a left hand side, accommodation. 6. 6.
87 বলছে তো।
6 accommodation.
আচ্ছা, accommodation.
88,
Yes, 8 family living in rented house and not owning his own house, or family living in own house. মানে এটা কি দাঁড়ালো?
You are in rented house or your own house?
Rented house.
Rented house.
Rented house.
সাবমিট করেছে দুটো কন্ট্রাক্ট।
বানান দেখো, বানান দেখলে তো সই হবে না। রেলওয়ে লিভিং বানান দেখো।
Not owning his own. Oh.
লিভিং
Family living.
LIVI এর বদলে LEAVI মানে ছেড়ে চলে গেছে। Family living in rented house and not owning his own house, or family living in own house. These are the two criteria.
Yes, I have, my lord, I have.
Suppose you are residing in your own house, how much will you get?
Nothing.
Acha. And if you are in a rented house, you
Then
will
I will get 15 marks.
15 marks. Now, as regards your residence, one report is you are residing in a rented house.
Yes.
And the other report is you are residing in your own house.
No, yes. Yes, but my lord, they have mentioned, they have, my lord, prepared a report, my lord, on the basis of the inquiry.
You wait to see your client's house.
No. My lord, they, my lord, prepared the report on the basis of his neighbor. Your lordship, kindly see page 104. During the interactions with the neighbor. 104. During the interactions with the neighbor, they also stated Srimati Purnima Adhikari, wife of such and such, staying permanent in his.
We are sending you, Mr. Bodua. You go and conduct an inspection and report where your client is residing.
Let my lord BSNL again make an inquiry, my lord. I have no objections.
বছর পরে আর কি compassionate appointment?
My lord, from 2001, my lord, they have fighting.
Survived for 22 years, Mr. Bodua.
So, my lord, from the High Court to, my lord, the tribunal, my lord. They are, my lord.
We understand. That's right. Who is your other side?
Mr. S.N. Chattopadhyay, my lord. Shantanu Chattopadhyay.
Respondent did file details of the officers who inquired about the family status of the petitioners and also the Mr. You're sure they have not given you any copy of the evidence?
No.
Give a notice to the respondent.
Yes, my lord, I have given the notice to the all the parties. I have every service I have filed.
How have you done? বাইশে জুন অর্ডার হয়েছে, 22 জুনের অর্ডার।
সব থেকে মামলা।
No one affidavit or service filed by the petitioners be kept on record. Stop. No one appears on behalf of the respondents and no accommodation has been sought for. Stop. Mr. Bodua, learned advocate appearing for the petitioner submits that in spite of an earlier direction on 22nd of June 2023. In spite of an earlier direction upon the respondents on 22nd June 2023 to file a report of details of the officers who inquired about the family status of the petitioners and also the details of marks awarded as per weighted system. In spite of an earlier direction on upon the respondents to file in spite of an earlier direction on 22nd respondents to file a report in the form of an affidavit no such affidavit has yet been filed. Submits that in spite of an earlier direction on 22nd June 2023 upon the respondents to file a report of details of theirs to inquirer, to file a report in the form of an affidavit of details of the officers. Personal appearance. Personal appearance. Shantul, you don't know the advocate, mister?
Yes, yes, my lord, I know him.
Please the matter for further consideration in the daily supplementary list of this court on 8th of on 6th October. Stop. Petitioners are directed to intimate this order to the learned advocate who entered appearance on behalf of the petitioners immediately.
The matter will appear on 6th October. In the meantime, my lord, I may get the copy of the orders, plain copy of the or server copy of the order in the meantime.
No, we don't put up in the server. We all keep the orders, we sign it and we keep it in order. No orders are uploaded.
I have deeply pleased.
It is uploaded either on the day it is part or on the next date. We follow that practice.
So, my lord, I only inform him that matter will appear on.
Get it in the server today at 8 o'clock at night. Get your order.
I am deeply pleased. I will serve the copy, my lord, immediately.
ওইটা দেখবে ওই last
চিঠি দিতে হবে না? চিঠি দিতে হবে।
Get hold of your other side, intimate him by a letter. We have dictated the order in front of you.
I am deeply pleased.
The matter is related to the compassionate appointment of the BSNL employee, my lord. The petition, the person.
Have you served?
Yes, my lord, I have served, and last occasion, Mr. Anil Gupta was appeared and he took adjournment, my lord.
It appeared before us.
Yes. Mr. Gupta, Anil Gupta was appeared on behalf of the respondent BSNL. And on that, on last occasion,
Any contempt application filed before the tribunal?
no, my lord, it is the compassionate ground related matter. Tribunal was rejected. I am for the petition.
For the petitioner.
My lord, in respect of the BSNL employee, my lord, in the year of 2007, my lord, the weightage point system was introduced. And according to that system, my lord, if any person is got 55 or more marks, his case will be considered. And it was also stated in that scheme that if his case was rejected earlier, that was also again considered on the basis of the 2007 scheme. But my lord, my case is that my case was never considered on the basis of the 2007 scheme. Rather, that was considered on the basis of 1998 scheme, my lord. And in spite of direction, first application was filed when before the learned tribunal. Learned tribunal was specifically directed upon the respondents, BSNL authority, to make an inquiry and consider the case on the basis of the scheme. But my lord, never inquiry was held on the basis of a frivolous report that they have going to try to find out where I am residing. And on that basis, my case was rejected. And thereafter, tribunal was again directed. And that on that basis, same thing was happened. No personal inquiry was held. When I have filed the second application before the learned tribunal rejected my case on the basis of, on the ground of limitation. But why not? My person was died in the year of 2000 and December 2000. Immediately thereafter, I have applied on 19th of February 2001.
Come on, 6th, we have kept a matter on this weightage point. Let us see. Give a notice to your other side.
So may I prefer, my lord?
Mr. Evidence of service filed by the petitioners be kept on record. Stop. In spite of service, no one appears on behalf of the respondents and no accommodation has been sought for. Mr. Ghosla, the advocate appearing for the petitioners is present. Stop. To give a further opportunity to the respondents to appear and contest, the matter stands adjourned. List the matter for further consideration in the daily supplementary list of this court on 6th. Yes.
My lord, shall I serve notice?
Yes. The petitioners are directed to intimate this order.
Mr. Anil Gupta or upon the, my lord, the
Learned advocate who has the learned advocate appearing for the respondents.
before this honorable court.
Yes, naturally.
Yes.
You said Mr. Gupta is
Yes.
immediately. Yes. And to file an affidavit of service on the return. Serve upon the advocate, file an affidavit of service.
Good.
The respondents.
At 50, I am appealing for the petitioner. My lord, in earlier occasion, as per your lordship direction, my lord, I filed my supplementary affidavit annexing the appointment letter got in the same, my lord, notification. They followed and they gave appointment in another candidate.
Have you given a copy?
Yes.
To your friend? Mr. Bajpayee, you have got the copy?
Yes.
The petitioner before your lordship, my lord, came before these honorable high court, my lord, that is 4th time. In 3rd time, my lord, they file OA application before the tribunal, and my lord, last occasion, tribunal records send back to the authority to reconsider the same. That is page impugn order, my lord.
23rd December.
Yes.
23rd December order you have challenged.
Yes. That is, my lord, order.
Joy Sarkar.
हमने लिखा है
23rd December 2022. Page 58 onwards.
Why you are agreed by this order?
My lord, in earlier 3 occasions, my lord, the writ application has been, the way application has been filed. And first, that order has been passed, my lord. If your lordship kindly say page 18. My lord, the scheme is in the year 2010. And if your lordship kindly the scheme for a moment.
How
that
you
is
are agreed by this order?
My lord, again, my lord, tribunal
So that
send
is
back
because-
for
that is-
reconsideration.
That
And
is
in-
because you have said that some persons have been given appointment.
Yes. Some
They
person
will
has been-
consider that.
Some person already given appointment on that scheme. Now they, my lord, refuses the same by declaring that another notification has come, subsequently has come, and so, my lord, I have
They
not.
have taken the decision. They
Yes,
have
ma'am.
taken the decision.
Impugn, speaking order they passed. After that, I challenge.
After that, it has been asked to be re-examined.
Re-examine. My lord, that is my challenge before this honorable High Court, because in earlier 4 occasions that was sent to the department, and department in various time rejected this way or that way, and after that lastly only, my lord, reconsider. If your lordship kindly see the speaking order passed by the railway authority, that is page 40.
40.
Page 40. Last speaking order. 40 onwards, and page 41 is the ordering portion. Second para. Honorable High Court, Calcutta, while disposing WPCT number 74, 2016 on 8/2/2019, directed the respondents to consider the applicants of the said WPCT who were under age bar, that is ineligible due to overage.
Where you are reading?
My lord, page 41, second para, top. 41. Honorable High Court, Calcutta, while disposing WPCT number 74, 2016 on 8 February 2019, directed the respondents to consider the applicants of the said WPCT who are under age bar, that is ineligible due to overage. Accordingly, suitable actions has already been taken for compliance in respect of only those eligible applicants who are involved in that WPCT. The SLP filed by the Railway Administration against the order of Honorable High Court, Calcutta, in WPCT 74, 2016 was rejected by the Honorable Supreme Court, considering the peculiar circumstances of the case, which was thus confined only to the applicants and not a policy accepted in rem. Moreover, since 2014, this railway has not offered any appointment suo motu to any of the land losers applicants, as clarifications was sought for into the matter by this railway from Railway Board on the issue of appointment of land losers against land acquisition. Railway Board by number such and such, dated 31st/12/2014, had communicated that the policy of appointment of landlords as stipulated in board's instructions dated 16/7/2010 was under review. The entire policy has subsequently been withdrawn by the Railway Board's order circulated under letter number such and such dated 11/11/2019. Malad, they are here, Malad, they said that all entire circular Malad had been gone by a letter dated 11/11/2019. If your lordship kindly say the page 26, the order passed by in previous occasion by the tribunal. That order has been passed on 3rd December 2019. At that time, nowhere it was stated that this notification has been gone and new notification has been come, cancelling the previous notification. If your lordship kindly say page 26. Page 26, Malad, kindly say the date of the order. That is 3/12/2019. My matter. OA 350-1070/2018. Hard on 3/12/2019. At that time, no whispering about this notification of cancellation of notification. And deciding all the facts, the tribunal passed the order and specific order has been given to give the appointment as per other candidate who they gave appointment on the basis of the circular dated 2010. And then kindly same for a moment, page 41 again. In view of all the above aspects, it is seen that Bijoy Sarkar, the applicant, in this way, such and such, cannot be considered for engagement in railway service, since the applicant was in no way involved either in WPCT number 74/2016 or in CAN number 3935/2017. Further, the entire policy has, however, been withdrawn by Railway Board's order circulated under letter number such and such dated 11/11/2019.
Now the only point is whether you have been discriminated.
Yes.
So if you have been discriminated, the court has asked to re-examine. Your contention is when I earlier came, when they rejected my claim in 2012, in 2013, 2015, at that time, what was the ground? No prescribed formal application is there, etc. There they did not say that they have withdrawn the earlier circular, because that withdrawal was in 2019. Now today, if the circular has been withdrawn, you have no avenue to get employment. Suppose today they come and say we have withdrawn that policy. Court cannot now say that no, you cannot withdraw it just now. So what the court has done is that if you have given benefit to others who are similarly situated, then re-examine and extend the benefit. So what is the wrong in the order? Tell us.
Malad,
your argument, if you insist, then we have to call for affidavits and hear it again. It is your choice.
Malad, your lordship kindly call for Malad.
Why? Why do you want to waste your
time? Because Malad, they did not consider my case within a time, that the time frame. And Malad, again, I have to file another case before the tribunal. And Malad, in earlier 4 occasions, they rejected my claim separate ground
for interference in the present writ petition.
And Malad,
whether the respondents will reject or not, whether respondent they will again delay it or not, that is not a ground for interference in the writ petition.
And Malad, in the for 2010 notification, Malad, they already gave maximum applicant gave appointment, and in the tribunal
So
order,
that point you have taken in your original application.
that was taken, and order has been specifically
kindly read the order. Unnecessarily you are going on. Please read the order, what the tribunal
Malad, tribunal Malad send back to the authority, reconsider my case.
what ground?
That Malad others give appointment, Malad they did not give me appointment. For that reason, reconsider the same on the light, in the light of the 2010 notification and as well as 2019 notification.
Where you are
Malad,
saying so many things. What is there in the order?
Malad, that is impugn order. If you let's say kindly say page.
We are on page 59.
59. 4, bottom. Considering the above submission without expressing any opinion on the merit of the claim of the applicant, we deem it fit.
Paragraph 3.3, read the two paragraphs.
At hearing, learned counsel for the applicant submits that similarly circumstances person have been favored with employment in respect of such project.
Next.
Meanwhile, the applicant,
Go slow. Next line.
learned counsel for the applicant would submit that a direction may be issued to the respondents to reconsider the case of the applicant
So,
in the light of the
so
railway circular.
what did your counsel tell before the tribe? Did the council say that you decide the matter here? You yourself sought that considered the matter in the light of this.
Yes. That is true, my lord. Council, my lord, submit. My lord, but in my lord, another time.
Now a new council appointed, new submission will be.
My lord, in one hand, my lord, tribunal said that that should be considered under circular number RB 99/2010. Another, my lord, RB 19.
Tribunal did not say. Your council said.
Yes. That is.
Council said that consider it, since you have given to others, you consider my case in the light of the search. Next, he further submits that he would be fairly satisfied if appropriate direction is issued to consider his case. Yes. He interfered.
Well, I annexed one appointment letter that was another person given, and they are admitted, my lord, they gave appointment of 28 candidates in earlier occasion when the way application heard by the tribunal. And from 2012, my lord, I am 2010, first order 2015, I am suffering.
No, considering the above submission. Order or light of the sun. Without influence with the other. With the light of the representation ei to boleche. Did this supplementary affidavit documents did you give before the tribunal?
No.
Where is your representation to the tribunal, which was last considered? In your original application, did you mention this discrimination?
Malad, in the order sheet, Malad, discrimination, Malad, point of discrimination is already there. Malad, that order passed, Malad, in the on 2019 that I annexed from page 26 onwards. Page 26 onwards. That discrimination point already taken.
Page 26.
26 onwards.
Where is it? 26 may be your first.
No, first, that is third.
Third?
Yes, third application before the tribunal. 26.
Achha, come to the supplementary affidavit. How do you say that it is similar?
Supplementary. That is after, if your lordship kindly see page 6. That is Sudeshna Paja, my lord, one of the applicant in the tribunal, and this
Sudeshna Paja was a person in the tribunal.
Yes.
Where
My lord, kindly see in compliance of Honorable CAT Calcutta's order. Approval of the competent authority has been communicated for appointment against land acquisition quota by letter under reference Sudeshna Paja such and such.
Where do you
Page 6
of the supplementary?
Matlab, top appointment of land user Tarakeshwar Bishnupur new broad gauge line project in favor of Sudeshna Paja. Then, my lord, in compliance of Honorable CAT, Calcutta's order, approval.
Which order is?
My lord, that is order page 26 in my application. Page 26.
Sudeshna was a party in the 23rd
Yes.
December 22.
There was a my lord, bunch of applicant on that. My lord, Sudeshna Paja was a party. Page 25 onwards.
We are talking of this order of 23rd December.
Well, previously one order has been passed by the tribunal.
Why don't you answer what you are asking? In the order which you have impugned, that was passed in several original applications. Was Sudeshna a party there?
Sudeshna party, one of the application, that order has been passed in the year 2019. Page 25, that order I annexed. And Papia with my lord, with Papia, my lord, I file application. Papia also got appointment. If your lordship kindly call for the record, my learned friend will show everything. Who got appointment on the basis of this order passed by the tribunal. Page 6. Well, in compliance of Honorable CAT, Calcutta's order, approval of the competent authority has been communicated for appointment against land acquisition quota, white letter under reference Sudeshna Paja.
So this Papia Das you have mentioned, no?
Yes.
This Papia Das
With me. With me in earlier occasion.
maybe. Papia Das-টাকে দিয়ে দিয়েছে 15/6
Similarly situated.
দাসকে দিয়েছে prior to Sudeshna was given appointment when?
16.
16. All prior to the new circular.
2015, my lord. And Papia also given, my lord, after that. My lord, that is.
Papia given.
Well, that document was not with me because, my lord.
We are giving you that document, page 23.
Page 23. Yes, Papia Das and Vijay Sarkar.
So Papia C got appointment when? 2017. Second para. They placed reliance on 16 July 2010.
Well, I am struggling 2015. All are 2015. First application has been filed in the year 2015. And they rejected my claim. After that, my lord, they admitted 28 candidate has given appointment. They himself admitted.
In any application, was Sudeshna and Papia parties like you? In any original application, which page? Please show us that Papia and Sudeshna are similarly situated.
With you.
একটা লাইনও এখানে লিখে। Show us. So many pages you are showing. Where do you have written that? Show us that you are exactly similarly situated. Show us.
In the OA application, my lord, they are party.
Which OA application?
That is page 18.
Page 18.
Papia Das and others.
Page 18, this is the order passed in Papia Das and another. You were there?
Yes.
Papia Das and another, you were there?
Yes.
So bring that original application.
2015 application.
To show us that original application.
This is the first application.
Yes, Mr. Bajpai, then why should you not give?
He referred an application. He accepted the compensation first, 24,000. Then he came out with an application for appointment. On the question of land acquisition, he accepted the compensation.
Then why didn't you say that in your order?
My
Which
lord,
was challenged
that
before
is
the tribunal?
no, that is in the
That was not a ground for
no,
rejection.
I am not making it a ground.
Then don't say that, Mr.
No, my
Bajpai.
lord, it is they who have said that in paragraph 4.
No, that is not an issue before us.
No,
So the question is, the application was made in 2016.
You only tell us whether Papia and she is similar.
In that event, my lord, I will.
Page 18, Mr. Vajpayee.
Yes,
she
that is-
says that.
She says that, but in that event, my lord, I am to file a reply. The entire,
yes, you
with everything in detail, because this is so haphazardly annexed and because this scheme has been withdrawn, and in lieu, they are paying and
The petitioner filed this case, whether this point was taken, that Papia and this petitioner was not similarly.
no, that point was not taken. That's why, my lord, I was beseeching your lordship.
No,
that-
page 19, you see, this page 18 is the order
Yes.
of Papia and another. Tribunal directed, consider it in terms of your earlier RB circulars. Now
2010 circular.
kindly come to page 19, capital A. 19, capital A, you reject both Papia and this person on the ground.
No formal application in prescribed.
Well, this question came up before the coordinate bench, wherein this petition was dispute was largely discussed, although the order is not readily with me.
Before earlier it was heard by any?
No.
Then
In the identical case, with the same sort of disputes, my lord, it was restricted to the petitioners only on the question of age bar. If during the pendency of the application, their age bar, otherwise it will be restricted to the petitioners. Now the question is, my lord, that's why, my lord, repeated occasions, my lord, they are referring this WPCT 74. That was decided by my lord Justice Dipankar Datta, as his lordship then was. And
why you are going to those issues, Mr.
No,
We are on a simple
if there is any discrimination, definitely I am with my learned friend.
original application.
My lord, original 2015 application at this moment not.
Then how did you, are you submitting that my client is
Yes,
there?
my lord, I will, my lord, so before your lordship that 2015 Papia along with me, my lord, I was, we are the applicant before tribunal.
Papia and Bijoy.
Papia and others. There are
No, Papia
and
and
Bijoy.
another.
My lord, I will show.
And another, not
Yes, yes.
others.
Yes,
Come to page 23.
এখানে ওর নামটা কোথায়?
because my lord,
My lord, all such issues.
contempt application has been filed, page 23.
We have got.
Page 23. The OA number is there. Papia Das and Bijoy Sarkar.
Wait.
The last line of the contempt order, page 23. One of the preconditions is he should be displaced from the only last line.
You are applying 16th of July 2010.
Yes.
So your argument as regards new circular will not come in this.
No, I am not. I have not submitted also.
Your officer has said that I will
You
not
have
consider.
been. You have not been displaced as a certified by SLAO Hon'ble by his letter number, sir. So two different cases.
Now you have
Maybe he has been displaced from his only place, and this
As
Papia.
per para 1, 2 of the Railway Board circular, provision for employment is confined to the cases where it must be ensured that displaced person has not received any land from the state government in lieu of her land acquired. In the instant that you have not been displaced.
Yes.
তার মানে both Papia and Bijoy were not displaced. As such, they were not entitled. But you have given Papia.
If there is any discrimination, I repeat it, your lordship, my lord, that if there is any discrimination, I am with my learned friend. I am not against anybody's employment. But the question is, my lord, let me go through it and let me file a short affidavit that yes, either they are discriminated or for some other reason, these two have been separately treated.
Ashok, the present writ petition has been preferred, challenging an order dated 23rd December 2022, passed by the learned tribunal in several original applications, including the original application filed by the petitioner herein, being OA/350/405/2021. His Hon'ble learned advocate appearing for the petitioner submits that the petitioner, along with one Papia Das, preferred an original application being OA/350/00027/2015. Stop. The same was disposed of by an order dated 10th of December 2015. Directing the respondents to consider the representation received in terms of RB number 99/2010 in accordance with law.
এই Papia দাসের appointment কোথায়? But Papia দাসের appointment is not here.
Papia,
Papia, why not? I am not collecting, my lord. I heard that this is the another person, my lord, because all appointment were later, my lord, lying in the record section of the my learned friend's office.
Once,
But all they have.
and there is no such appointment in.
But how I am collecting that, my lord?
But
If your lordship kindly call for the record, everything, and if your lordship kindly for a moment, page 28.
ও মাথাটা খারাপ করে দেবে, ওয়েট না। কোনটা চাইছো, পেজ 18?
I don't find Papia Das in appointment letter.
এটা পাপিয়ার বিজয়,
He may be petitioner.
এটাতে পাপিয়াকে দিয়েছে, বিজয়কে পাপিয়াকে দিয়েছে, এখানে পাপিয়া
কি করে পাবো? তো আপনি দিয়েছেন, আপনি পাবেন।
Only Sudeshna has been
Page 20, অর্ডারে বলা।
28. বলো না, বলছো না তো।
বলছি তো স্যার, স্যার ওই মাথা খারাপ করে দিচ্ছে। তো বলছি আমি 28 এর লাস্ট কোশ্চেনটা
বসু দেখি, বসু।
Well, kindly see for a moment, page 28, last para. Page 28, last para. They are
Fine, but
last para, page 28.
whether
For a moment.
she has been given appointment or not, that is to be looked into.
Well, the respondent have, however, emphatically admitted that although the project was stalled, the General Manager, Southeastern Railway accorded approval for extending employment assistance to the 28 land loser candidates under land loser scheme in Group D category at the material time.
But where is Papia?
2015, my lord, there was a
See, Ms. Hon'ble, you also understanding what we are wanting to know. Don't make unnecessary
Yes,
stuff.
yes.
You show us any document from which it will appear that the Sudeshna, Shubhodip and Utsav are similarly situated with the petition.
2015 original application, they were the applicant.
No, they were only two persons were the applicants in 2015. One was Papia and the other was Bijoy Sarkar. Then
Mala 2015, except Bijoy and Papia, others 28 candidate was the applicant. My lord, I will.
from we come to know.
2015, my lord, the original application, I will show before your lordship.
Kindly come to page 18, 1-8.
Page 18, Papia Des and others.
Abar
Another.
and others.
And another.
And another.
That means
Then
we
how
are-
that the other persons were part?
yes.
You are saying that along with this petitioner and others' name also do not feature in the original applications which were decided. He relieved them.
In the order sheet, my lord, there was a reflection. My lord, 2015 OA application, I will show hand over before your lordship. Then everything will be clear. 2015, that my lord OA number such and such, my lord, I will produce before your
The
lordship.
order passed by the learned tribunal in page 18.
And I will elaborately, my lord, discuss that from 2015 original application, who are given appointment.
No, that is true, but in 2008,
Yes, my lord, page 28, my learned friend submitted before the tribunal that they gave 28 candidate appointment.
it order লেখা আছে Papiya Das and another.
হ্যাঁ, তো ওইটা তো
Papiya Das and another. So Papiya Das has not been given a point.
হ্যাঁ, they are given appointment.
দিয়ে দিল পাপিয়াকে দিয়ে দিল বলছে কিন্তু ডকুমেন্ট নেই পাপিয়াকে
সঙ্গে সব ছিল কোথায় যাচ্ছে দেখুন। একসাথে বিষয়
Your case has been rejected on 3 occasions.
3 occasion by different type of speaking order.
In 2015, you took the pleas that you have not submitted application in prescribed form. First rejection. Second rejection, that you have not been displaced.
Yes.
Third rejection is said that you are not involved in WPCT number 74. And now, yes, policy has been changed by a circular of 2019.
Well, all this is,
Fighting his cause since 2015.
that is true.
Now giving a retrospective for a circular, you stated that new circular has come, you will not get.
No, that has been with, that is true, my lord. But the question is, my lord, he is to satisfy your lordship definitely that there is some amount of discrimination has been done by the authority by giving somebody and not giving all those they are similarly placed or something. I am definitely with my learned friend, but the question is, my lord, that every time, and the questions that fell from your lordship, my lord, that have been merged with the order passed by the learned tribunal. And now it cannot be reopened on the earlier orders if you
cannot be.
No, the question is, my lord, all these points have been considered by the learned tribunal. That earlier 3 times the question was rejected. And even after that, my lord,
You are seeking one after another ground. How many times one litigant will come and approach the court?
no, they have approached the court 4 times in the tribunal. But the last order speaks that all these issues have been.
Court does not encroach your arena, and you are going on taking same stand, only different language and different order.
That is, I leave it to your lordship. My lord, I have no other, because lordship kindly give me a chance to only to see that yes, they are discriminated, and
We will ask your principal chief personal officer to be before us along with all the records.
all right, if
That
your
will
lordship,
solve the purpose.
that will solve the purpose. If they can satisfy your lordship, I have no objection.
ওদের কি পাঠিয়ে নাও ওদের কাছে পাঠিয়ে জীবনে আর এই করবে তুমি
এটা কোথাকার?
না দেখাতে পারলে কি করে ও দেখাতে পারছে না এটা সামান্য
You, Mr. But you have to prove that such and such Sudeshna or Subodhi Utsav They are similarly situated.
Not a single line you have written. See,
That their land was also acquired under the same project.
Nothing. That's why so
And
haphazardly.
their case was considered by the same.
My lord, in the order sheet, my lord, in page 28, my lord, there was a discrimination there, and my learned friend already admitted that fact. That 28 candidate already given from that land loser category,
Maybe
depriving me.
It may be 100.
You are similarly situated with that
Yes.
28
Yes.
candidate.
Yes.
You just satisfy us.
That is my only
And my lord,
issue.
in the order, my lord, if your lordship kindly say the order
you will
portion.
not satisfy. You will show us different pages.
Look, your case has been directed to be considered in the light of the circular of 2010 and 2019. And you raise this point of discrimination. No order has been passed on that issue. That is only your case.
Yes, and 2019 circular, my lord,
And
they
this discrimination,
stated that they cancelled 2010 notification, which date they disclosed. But
No,
after
bring-
that order has been passed.
Bring all your original application.
Yes.
and
Yes.
the
Tomorrow,
discrimination
bring all
was
your-
also surfaced because only in the last application before the tribunal, not before that. The question of discrimination, that somebody has been discriminated.
Discrimination is already there in the order sheet. All entire order dealt with discrimination, regarding discrimination.
We are not taking this on record, supplementary evidence. You prepared a fresh supplementary evidence.
Annexing all the original application.
Okay, কি বলছি আরো কি?
Yes, yes.
To allow Mr. Bajpayee to take inside, he also must have certain documents. He can question his client then on the basis of the documents. And you write only discrimination, finished. But what discrimination, which original application, which applicants, no details you have. ওই ঢুকিয়ে দিয়েছে তো কি করবো
And another discrimination
come,
is
you come, when can you come with the fresh supplementary?
My lord, within a 7 days.
if after puja, my lord.
No, no. My
Let
lord,
it be.
within a 7 days, my lord.
I will be.
We will, you give back that supplementary. We are not taking it on record. এটা ফেরত দিয়ে দেবো আমার।
No, that I am giving, Lord.
দেখো একটা
Because
supplementary।
always a threat is coming from her side that don't open your mouth. So that is the problem. So I was sitting tight over my seat. So now he is saying that this, that.
Nothing to be required to be uttered.
That is a, that
By
is,
speaking or passing speaking order one after another, you are just doing your job.
Lordship knows the railway people. My lord also has dealt with many cases of the railways.
না, এটার basically
Nothing, my lord, I am returning it.
You have already affirmed, na? You have already affirmed. So, Mr. Bajpayee, we keep it after some days. You take instruction on the whether any co-applicant, whether any co-applicant has been given a point. If that is so, if it satisfies you, you come to us.
Well, there are two applicants. One is the my learned friend's client, and the other one is Papiadas.
No, no, there is another
There are
group of
other
original
cases, my lord, I do not know, but in this case, what he is advocating, they are, my lord, two applicants.
2000.
Papiadas and another.
Saying Sudeshna, Subodhi,
My lord, their cases may be different because that record is not with me.
All the, my lord,
But the question is, my lord, only in her case, the Papia and Vijay Odhikari has filed the application. They have filed. So, my lord, whether Papia has been given appointment and Vijay Odhikari has been deprived, that is the moot point that is to be
not only Papia, whether any similarly situated person like the petitioner has been given appointment
because their details,
and the petitioner has not been given in this way.
That is the
Whether it is
thing.
Papia or Sudeshna, such as.
He has specifically mentioned in
No,
the
no, I
affidavit
am not
that
mentioning
these two have
2015
been given appointment.
original.
So that's why if this affidavit is not taken into record, my lord, in that event, my lord, definitely the other persons who are similarly placed, they may be.
No, সেটা recorded here. You produce the original applications. Miss Asun. Miss Hon'ble learned advocate appearing for the petitioners files a supplementary affidavit. Stop, let the same be kept on record. Stop, a copy of the same has been handed over to Mr. Bajpayee, learned advocate appearing for the respondents. Stop. Mr. Bajpayee is directed to avail necessary instruction. Stop, list the matter for further consideration in the daily supplementary list of this court on.
My lord, possibly it would have been better that the chief personnel officer should come with the reports, because this will be unending unless one after another. My lord.
On 12th of October. Yes.
My lord, I am, my lord, hand over the copy of the supplementary affidavit. Supplementary affidavit, my lord, with me.
Yes, yes, give it, ওইটা recorded নিয়ে নাও। Give the copy. We are relying on this. Next day you bring the original applications.
Great.
The fixed করলো কবে?
12th October.
Mr. Bajpayee, come with that instruction, you come with your original.
My lord, my only instruction is whether she has been discriminated with the similarly placed person or not. That is the only issue. And if it is discriminated, my lord, I am with my learned friend.